we are starting. We are starting the second day of the conference.
Thank you. Good morning to you all. Buongiorno a tutti. I'm very grateful to Professor Sirio Zolea for this invitation and so for inviting me to chair this session with our keynote speaker, Stefania Palladini. She has a very interesting, I could say also intriguing presentation titled The Case for Space Sustainability, Crowded Orbits, Debris Crisis, and Global Space Governance. It's very interesting because this problem of debris in space is maybe the huge problem in the next future before the exploitation of resources in outer space. But I give the floor to her. But just before doing that, I would like to propose to you all just a few considerations about an issue that, in a sense, occupied my mind for a little time. This has to do with the anthropological presuppositions of our experience in outer space. And not only our experience from an anthropological point of view, but also from a legal point of view. My question is as follows. Are we sure that the boundary conditions underlying our anthropological experience, our conduct on the Earth, will be the same in outer space? And are we sure that this change, if it is the case, would not change also reasonability, reasonableness, feasibility, viability of our legal categories? I think that something very difficult we can bump against in outer space. Something that is waiting for us and the eyes are not able to imagine, or maybe we don't want to imagine for political reasons. But these political reasons can prevent us to calculate, we can say, the ingredient of sustainability. And I repeat this, let me iterate, the feasibility of the practical implementation of our categorization, not only of the space, but also of the legal categories, including our spatial experience. Let me give just a little example. For if I put some water in this glass here, I have the property, the ownership of this water. So I can say that, for example, if Stefania takes this, is stealing this to me. But if I do this in other space, in a few seconds, water will turn into smaller or larger droplets continually wandering in the space. To consume this, to swallow the water, I had to continually displace, shift my body in the space to become able to catch them and then swallow. But the problem is the property, the ownership, the possession, the practical possession, it is relevant with regard to the theft, both in English law and Italian law, includes also this shifting in space, the way in which I occupy the space by means of my body on the move. So the idea of ownership will include also this movement, this resemantization of space. And what about if more people are consuming the water in the glass that is wandering in space? This kind of intermingling of droplets. And what conditions I can say that someone is stealing my droplet? Of course, is an hyperbolic example, but what I'm trying to convey is the idea that maybe the naturalness of boundary conditions will completely disappear, evaporate. And this could have a lot of consequences. Also, our ideas about property ownership, the proxemics, that is to say, the semiotic interpretation of the relationship between body and objects, between different human bodies. Many things will change, I think. But this change could have a lot of consequences, or I think, even on the way in which we can imagine the exploitation of celestial bodies. If only because celestial bodies are moving objects. They are a mobile good and an object of real estate. So, are they one thing or the other? It's very difficult, I think. So, the conflicting attitude that many political representatives are showing today, I think that could be considered untimely from a cognitive point of view, than from an axiological or political or ethical point of view. And so I discussed about this with Sirio, and Sirio told me it's about maybe in the future we can find some solutions by trial and error procedures. But I think that is a danger looming in the horizon because law has a performative effect. And the reification consequences of the east-west divide are very dangerous. In the past, we experienced how many negative consequences they could have on our ability to find a reasonable solution from a cognitive point of view. What is very striking, I think, is that we are debating about this problem from a legal point of view, but the scientists are saying to us, are you sure that you can exploit these resources? Are you really convinced of this? So I stop here, but I want to give you just some doubts which reflect before react. Because even the theft is difficult to be thought of. So we can imagine what could happen, all the hindrances that we can bump against to reach in outer space. So I don't want to take other time to our wonderful keynote speaker. So you had the floor. Thank you.
Thanks to Mario Ricca for this great introduction. And first of all, thanks to Roma 3 and Sirio for organizing this fantastic meeting. Honestly, 10 years ago when I started writing about space, there was nothing like that around. It's it was the early days, but you could find this kind of different opinion and contribution only on the trade exhibition, like Ferber was specialized on space, and it was or in very close group, not this kind of debates. So it's very good that now increasingly we have more and more people that are interested and consider space as a priority. And this is something that 10 years has changed a lot. Now, I am not a scholar of law. I say that immediately. I came to space from a security perspective and an economic perspective. And I started from a completely different perspective from what I'm talking today. There was cybersecurity, symmetric communication, encryption for satellites, something completely different. But increasingly, in the last 5 years, I focus on a different dimension of security, is what in the Copenhagen School of International Relations called non-traditional security, which is environmental security and sustainability. Why so? Because these are emerged like one of the main issues we have now in space. And this is something that is not confined to law, it's not confined to economy, it's not confined to security, it's becoming an overarching issue. Now, it's going to be a short intervention. So I don't have any answer. I just have question and just have perspective. Okay, what is the debate about security, environmental security and sustainability? I use both for a reason that you will understand why I'm talking, and also because I'm based in the UK, although I'm not British by birth, as my accent can give away. But I based in the UK. I work in the UK for the last 20 years. So and the debate about sustainability in space now is increasingly important. Now, any kind of debate about sustainability in spaces obviously has to start with the definition of the United Nations Committee for Peaceful Use of Outer Space. Okay, this is the working definition. Sustainability in space has the ability to maintain the conduct of space activities indefinitely into the future in a manner that realizes the objective of equitable access to the benefit of exploration and the use of outer space for peaceful purposes in order to meet the needs of the present generation while preserving the outer space environment for future generations. This is a definition in 2018. And if you go on the website of UNOSA, you find this all the alignment of the space sustainability with the Sustainable Development Goal, access to space for all, so the equitable dimension. So this looks very good and nice, and it is, except that this is not applicable because just as a starting point, there are no metrics, no KPI, let alone action plans. I mean, in which way this translates in anything that can be useful, apart from a general principle, is the problem, is the key of the problem. Another part of the problem is that this definition only considers sustainability in space, which is just one of the dimension. Now, in the UK and especially in Scotland, there is now, and I know there is a Scottish colleague here from Dundee. Yes, I probably are going to cover some of the things I'm saying today. In Scotland, the Scottish Space Agency has. I'm not saying it's the first because I don't know about the others, but it's one of the first that put the space sustainability as a roadmap, as a focus point on how we can do something practical to achieve this sustainability, but also in terms of enlarging the debate of what sustainability actually means in space. So it's not just sustainability in space, but also sustainability from space and sustainability for space. It has to be a wider debate. Why there is this attention in Scotland, I don't know. Probably because we have the spaceport, and the spaceport, there is, I mean, there are a lot of goods, but also a lot of problems that come from that. And let's say that now is increasingly in the last 4 or 5 years, there are workshops, there are conferences that try to expand this sustainability from a specific in-space component to a wider approach. And the one that is quoted below is one of the definitions that the Scottish Space Agency proposed in terms of long-term sustainability of space activities, which there have not just the component in space, but in a more general way. So what this means? Of course, the starting point is sustainability space, and this is what, in a way, we look the most because we have the more data available. And even if you just stop at that, it's quite a mess, just to say the least. And I'm not just talking about the debris, although the debris is the main, let's say, not the main problem, but the problem is under everybody's eyes. But it's also a problem of crowded orbit, because it's true that space is infinity, but the orbit we can use are not. There are orbits. There are the LEO, there are GEO, there are all these orbits. And if you look, for example, at the ITU documents, it's from the 70s. They were warning, look, what we are doing in a geosynchronous orbit is going to become a problem, because we are running out of frequencies. We need to have a sort of systematic approach to that to make sure we can preserve this environment. It's from the 70s, guys. It's not now. So, and with the number of objects sent to space, it's a problem of crowded environment. Also because, okay, you send things up, but how you retrieve them. Now, there is the 25 years policy that NASA has been advising. Now they move to 5 years recently. In geosynchronous orbits, there is the graveyard orbits. There are some sort of solution, but still it's something that has to be implemented by everybody, which is not at all the case. They think it's scary, and I will show you something. You see this? This is Leo Labs. It's if you Google Leo Labs, is live access to what is the situation, and this doesn't. I deselect debris because what they are, the debris they are shown there are just the huge debris, the big debris, the one that are being caused by ESA tests. Yesterday, Mola Griar were talking about ESA tests as one of the really the scourge of the space sector, which is true and is right, because if you look at the 10 worst breakup events, the majority are ESA tests, not all. There was the Iridium 33 with the Cosmos incident that was a huge problem, and this is we'd open another chapter that I won't because we don't have time. But ESA tests, of course, are a problem. But the issue here is that there is what is called the Kessler syndrome event that risk to make our orbit unusable, because as after a certain number of breakup, there will be a chain reaction effect. So now all this attention we give to debris is for this reason, because there are projections that consider now this increasingly likely if we don't do anything to address this. Now, the other thing, and I don't want to scare anybody, but this map just track around 20,000 object displayed, which are a minority. Okay, if you look at the UNOSA live registry, it's this morning we're about 17,000 registered, and it's about 85%, 87%, not everybody registered. And then there is just object launched to space. Then you have all the debris created. So there are ESA have a model, because we also talk here about models. It's difficult to track debris when they are smaller than a certain dimension. ESA with the master models, which are model, accounted at December 2023 for 130 million space debris objects of small dimension. Small dimension doesn't mean they are not dangerous. They are still dangerous, because if you look at what happens to the space station where they are obliged to move, because they are just a tiny particles that impact their operation. So this is a huge issue. And of course, now we have companies that now there is attention to that. So there are companies that are getting serious and invest on what we call the ADR, active debris removal. You have ClearSpace that got financing from the ESA, and they are preparing their first industrial mission. I spoke to them in February last June. Still early days. It's the most advanced solution, still early days. There is Astrospace that got, it's a UK company, got financing from JAXA, the Japanese Space Agency, but we're still early days. And also, even more worrying from my perspective, we don't have reliable cost-benefit models for how much cost, how much we gain from debris removal or debris mitigation. NASA last year published a study, a very big study on that, acknowledging that there are a best estimate, but models, there are no models. There are from a few million, from several hundred millions, depending how many debris are removed, but there are no costs. So just to say that there are a lot of work, it's something we are doing with my PhD student, try to get mathematical models, but the problem to get mathematical models to function, to have good data and reliable statistics, which still, as these early days, we don't have. So I won't go into details of that, just to say that this is a huge problem, and it's not the only one. The other thing is space tourism. Now, it's some that is tiny space tourism, okay? There are a lot of debate, for example, in UK, as we should even have a space tourism, considering how impactful it is for the environment. And apart the legal definition, there is not there is the legal definition of the European Space Agency on space tourism, but they are not a legal definition of astronaut or space tourist. There are a few. There is Virgin Galactic, there is the ISS visitor. There are a lot of definition, but there are not legally accepted definition. You know better than me. And when you don't have legally accepted definition, it's dubbed up to insurances. And so there are a lot of issues on that. But also there are a lot of problems in terms of what are the real costs of tourism, because it's not just the emission. There are studies, and here I have some models that we are not going to present. If anyone is interested, I can send you the link, because there are data set. The problem is that space tourism give away particles and black soot in a layer of the atmosphere where they are not present before, and we don't know the effect. So it's more than what it looks like just in terms of carbon emission. It's much more complex. And it's something that we don't look now. Now it's still tiny, but in the projection are scary. Okay, so, and space tourism is important for another thing that I will mention at the end, because it's something that part of the world look like what you associate the space to is space tourism. I will come on that in a moment. The second perspective I would like briefly to mention is sustainability from space. Now, this is I come to what Marco was saying about the concept of Earth, the concept of spaceship Earth, that we are living in a tiny world that is around the space, that we are all there in that together. It's something that has been around from the 60s. in our lifetime, but it's an important concept. It is something that there are debate and studies about how we can translate this in practical terms. Now, for example, an example that I often do is Melissa. Melissa is the water purification system on the ISS. That there is now the Melissa Foundation, and the technology is used in the desert by brewery in a lot of situations, in a lot of commercial application, because a very good example of a circular economy in act that comes from space. There is also the use of all data from space to actually transition into a low carbon economy. There are a lot of startups now in Europe that use publicly available data to actually help address issues on the continent. So there is a lot we can do with space data to actually help sustainability on Earth. This is probably something that we are going to see a lot in the next 10 years, 20 years, if we still have satellite, of course. But this is something that it's considered one of the really gain from space, apart from mining and all these kind of things. This is what space can do for us on Earth now. Okay. The third dimension is sustainability for space, and this is something more about the politics. Now, the problem is that until, as a world, as a nation, we don't have a vision from space for space in a sustainable way, it's difficult to get to agree to any kind of framework, a global framework that has to protect space. This is what we were talking before. Now, here it's interesting because there is an Inmarsat report that was done in 2022, and is a public available. I really advise you to look at that. It was the most extensive study ever done. It's 20,000 people surveyed in 11 countries, and from China, from the States, from Europe. It's really a very good investigation. And interestingly, the 45% of people in China associate space with space tourism. Okay, that's what, if you tell a Chinese what is space for you, is space tourism, which gives you an idea of how the different perception for space can be. the average on the rest of the world, it's 20%. Of course, all the world of the country survived, but it was quite a range of different sample in terms of answer. Then there was a lot of, with 46% on overall was satellite, and one of the fear was debris, environment, sustainability, especially, and this is I couldn't put here the demographic for obvious reason, but of course, especially the younger generation were particularly concerned about the sustainability of space, and the first thing was debris, of course. So until we don't, and this is something I'm positive about, until we don't really agree in which way we want to develop a sustainable space sector, we can't agree to any kind of global framework, which is part of the problem. The big problem, what happened to the debris today, is because we don't have the kind of framework that guide us. Way forward, well, difficult to say. There are, for example, in the Scottish Space Agency, there are some advice in terms of unilaterally imposed measure probably won't do a lot of good for industry, because we know private companies that are not necessarily happy to be told how to do business, but probably try to fund, to educate, to use space for good in terms of how to make our life sustainable on Earth. Probably this is one of the way to go. Of course, there are not easy and quick answer. Okay, it's just something that I think it's very important to keep in mind when we prepare our scenario. We are going to mine the moon, to mine the asteroids. We are going to do space orbital station for tourism. It's something that needs to be put into a perspective, also for security reason, because if there is things that the environmental security taught us is that wars happen also for shared resources. So space is going to become quickly a very scarce resource, incredibly to say, but this is what we are going to face. So even in terms of security issues, we need to consider this. And I won't take more of your time. Thank you.
Thank you a lot, dear Stefania, for this very interesting presentation. I think that we can learn an important lesson for this about sustainability. In other words, sustainability is not, maybe what I understood, is not to be thought as an heteronymous yardstick to think of space and about our presence in space. From this point of view, let me suggest you a very wonderful book about Dennis Cosgrove. It's titled Apollo's Eyes. It's the history, is a cartographic genealogy of the Earth in Western imagination. Has to do with our gaze about Earth and reflective gaze about Earth from the space. What a wonderful gaze through this barrier of debris. It's terrible. Maybe I think we really avert considering space as a sort of projection of the Earth. We are not to have an earthlet conception of space. And I'd like to leave you today with a suggestion that acts back Middle Age and a wonderful author, Italian author. This is, I read this before in English in a very, very terrible translation, but let me tell you the same passage in Italian. In Italian, the passage is this, is belong to Canto 22esimo della Divina Commedia. When Dante is leaving Beatrix, because he arrived to hated dimension of the paradise is its sky. He says, e vidi gli eterni gemelli, volgendomi agli eterni gemelli, l'aiuola che ci fa tanto feroci, tutta m'apparve dai colli alle foci. The threshing floor that make us so proud. This is the translation. That is not very efficacious, I think. But Dio aiuola che ci fa tanto feroci. Maybe if we consider the Earth from space, we can see our ferocious attitudes. And this could be a sort of warning about the danger of projecting in cognitive terms, before again, then in axiological, ethical, or political terms, this ferociousness over the space. Thank you. Thank you, Stefania. I think that now it's up to you to continue the conference.
Okay, good morning to everybody. I am Diego Zannoni of the University of Padova. And first of all, I would like to thank you very much, really, Sirio, for this invitation and for the impressive efforts of organization of this workshop. The title of my presentation is What is peaceful in outer space? What is peaceful in outer space? I know very well that this issue is not new. It has been the object of a very vast debate between authors and also among states. But I think that it is particularly urgent nowadays to clarify once again what are the limits states encounter when they carry out space activities, if there are any limits. I think that to clarify these limits is the first safeguard against the current tendency to progressively set aside the barriers against the militarization of outer space. So the relevant article here is Article 4 of the Outer Space Treaty. I will always struggle between two interpretations, so sometimes the reasoning might be difficult to follow. As you perhaps know, Article 4 is made up of two paragraphs. There is the second paragraph and the first paragraph. I will analyze the first one later on. So the second paragraph specifically only applies to celestial bodies and to the moon. On the contrary, the first paragraph is the only rule which is applicable, in addition to celestial bodies, also to the void space. So first paragraph is the only rule, the only prohibition which is explicitly applicable to the void space. So let's start from the second paragraph. The moon and other celestial bodies shall be used by all states parties to the treaty exclusively for peaceful purposes. Please emphasize exclusively, because this adverb is crucial. The establishment of military bases, installations and fortifications, the testing of any type of weapons, and the conduct of military maneuvers on celestial bodies shall be forbidden. And then it allows the use of military personnel for scientific research and other peaceful purposes. So this paragraph was clearly inspired by Article 1 of the Antarctic Treaty, because in both conventional texts, the general principle of the exclusive principle use is declared, is stated, and after this principle, there is a list of prohibited activities and of permitted activities. But there is a difference. There is a very important difference because in the Antarctic Treaty, in Article 1, there is a all-encompassing formula because it uses the formula any measures of a military nature. Any measures of a military nature are prohibited. So this is an all-encompassing formula. On the contrary, this formula is not contained in paragraph 2 of the of Article 4. So there is a debate here. This list of prohibited activities is only exemplificative, or is it a closed list? There was a debate, but now the vast majority of authors, and I agree with it, is in the sense that this list is only exemplificative, with the consequence that any military activity on the moon and the celestial bodies is prohibited, not only the ones which are explicitly listed. And the argument which is used to arrive to this conclusion is precisely the adverb exclusively peaceful, exclusively for peaceful purposes. It is the second paragraph. Let's go to the first paragraph. As I told you, this paragraph is applicable, yes, to the celestial bodies, but also to the void space, and this is the only rule which is applicable to the void space. It says states parties to the treaty undertake not to place in orbit around the Earth any objects carrying nuclear weapons or any other kinds of weapons of mass destruction, install such weapons on celestial bodies, or station such weapons in outer space in any other manner. So also here, of course, there are some interpretative issues. So first of all, Article 4, paragraph 1 only refers to celestial bodies, not to the moon, not to the moon. And it is quite strange because in general the Outer Space Treaty, also in the title, also refers to the celestial bodies in combination with the moon. And for this reason, there were some authors in the past that supported the view that this omission was intentional. I mean that the moon was not explicitly referred to because the drafters wanted the moon to be excluded from this rule and therefore from this prohibition. In particular, Yasin Tuliana was of this view, but I don't agree with this interpretation, and the vast majority of authors do not agree with this interpretation. First of all, because the ordinary meaning of the term celestial bodies includes the moon. Then it is not true that Article 4, paragraph 1 is the only rule in the Outer Space Treaty which refers only to celestial bodies. For example, also Article 8 of the Outer Space Treaty refers only to celestial bodies, not to the moon. It says that the state of registration retains the jurisdiction over space objects and related personnel while in outer space or on a celestial body. To argue that the state of registration has not jurisdiction on the space object on the moon is absurd, of course. And then the inclusion of the moon in the prohibition of the first paragraph is the necessary conclusion as long as we read the paragraph 1 in combination with paragraph 2. I mean, if the moon has to be used exclusively for peaceful purposes, according to second paragraph, at least it is prohibited. We have to agree that it is prohibited to install nuclear weapons and other weapons of mass destruction therein. Then there are also other interpretative issues. First of all, nuclear weapons and other weapons of mass destruction, paragraph 1 says, consistently with many UN resolutions, these weapons of mass destructions are radiological weapons, chemical, biological weapons, and any other weapon which have destructive effects similar to nuclear weapons. Then paragraph 4, paragraph 1, sorry, says that it is prohibited to install such weapons on celestial bodies in outer space and in orbit, to place them in orbit. What is necessary for a weapon to be put in orbit? The doctrine unanimously says that it is necessary and sufficient that an object makes a full rotation around the Earth, or is able to make a full rotation, to finish a whole rotation around the Earth, with the consequence that intercontinental ballistic missiles are not included in this prohibition because they do not have a orbital trajectory. Their trajectory is suborbital. They are in outer space only for a very short period of time before falling back to the surface of Earth. Okay, so this is the only prohibition which is explicitly applicable to the void space. Here there is the debate. The debate starts here. I mean, one could say that there is only this prohibition and that any other military activity is therefore lawful in outer space, but it is not the only interpretation possible. And in the past, there was also another interpretation which was supported by some rules contained in the Outer Space Treaty and by the travaux préparatoires. In particular, Article 9 and Article 11 of the Outer Space Treaty say that the exploration and use of outer space shall be carried out in a peaceful manner. They refer to the peaceful exploration and use of outer space. Article 3 of the Outer Space Treaty coherently requires that the space activities are carried out in the interest of maintaining international peace and security and promoting international cooperation and understanding, etc., etc. So, according to this interpretation, peaceful is more than peace, as antithesis of war. We have to admit that any military use results in violence, or may result in violence. According to this interpretation, any military use of outer space is unlawful because if peaceful use merely means that the use of force is prohibited, so it would be unnecessary, it would be useless, because a mere reference to the UN Charter of the United Nations and to international law in general would be sufficient. You know, according to Article 3 of the Outer Space Treaty, space activities shall be carried out in accordance with international law and in particular with the UN Charter. So, to state the principle of a peaceful use would be completely useless. But maybe the strongest argument which was used in the past by doctrine was the principle of benefit, which is contained in Article 1 of the Outer Space Treaty, according to which the exploration and use of outer space shall be carried out for the benefit and in the interests of all countries, and be regarded as the province of all mankind. So according to this doctrine, a military activity is never for the benefit of all mankind and in the interests of all states. Necessarily, a military activity is in the interest of one state or a group of states. Of course, but I am late, all these arguments are irrefutable, no? Because one could say that also the military use of outer space can be carried out in order to maintain peace. Also, the use of force authorized by the Security Council, according to chapter 7, aims precisely to restore international peace and security. And then one could say, at the end of the day, Article 4 applies, and Article 4 specifically contemplates only a prohibition, the prohibition to install and place nuclear weapons and other weapons of mass destruction in outer space. Also, other arguments could be used to support the view that only this prohibition exists and that any other military use of outer space is lawful. So there are arguments to support both views, both interpretations. I am concluding now. I think that there is a common denominator between the two interpretations. For sure, the use and the threat of use of force is prohibited in line with Article 2, Paragraph 4 of the UN Charter. What about the other military uses of outer space? The literature and many authors say we have to look at practice. And in practice, there is no doubt that outer space is used for military purposes. It is thanks to objects which are located in outer space that states are able to carry out most of their military activities on the ground. So they say we have to look at the practice as a means of interpretation of treaties according to the Vienna Convention of the law of treaties. I don't fully agree with this interpretation because and I am finishing. It deduces from a practice more than what it can. Because we have to make a distinction, to draw a distinction. Yes, for sure. Listening, detection, communication devices are used for military purposes, and they are for sure nowadays lawful. They are commonly used. But no weapon has yet been installed in outer space. So there are two different value judgments in this regard: weapons on one hand and other devices on the other hand. There are some elements in international practice which can be used to support the view that it is not possible to put conventional weapons in outer space, or at least that there is not a general opinion that it is lawful to put them in outer space. In particular, I am referring to the resolution which every year the General Assembly adopts, where it invites member states not to be the first to put a weapon in outer space. Of course, this resolution is not unanimously adopted, but it is an element we have to take into consideration. And then also during the discussion of the draft treaty on the prevention of the placement of weapons in outer space. There were more than 50 states, and they agreed that the notion of peaceful should mean prohibiting weapons in space, but allowing military uses of space. So what I wanted to say is that in light of this practice, we cannot deduce that it is prohibited to put conventional weapons in outer space, but we cannot also deduce that it is lawful to do so. I have concluded. Okay, let's go on with the panel. So it is a pleasure to give the floor to Alexander Simons of the University of Dundee. And the title of your presentation is quite long. Is the speed of law faster than the speed of light? Considerations of the impact of special relativity on the operation of law in the context of deep space missions. Alexander, the floor is yours.
Thank you. Am I switched on? Can you hear me? Brilliant, thank you. First of all, just like to say thank you very much to Sirio for the invitation. I've enjoyed every minute, and thank you as well to the University of Roma Tre more broadly for hospitality and everything else as well. So without further ado, I'll move on in the interest of time. But yes, as Diego said, the title of my presentation is the speed of law faster than the speed of light? And my presentation is based on 3 premises, effectively. So the first one would be that, well, legal jurisdiction, at least to some extent, extends to individuals in outer space. We've seen that in various instruments, and as well, it's been written about in the literature. Also, it rests on the premise that people one day in the maybe not too distant future will travel into what may be regarded as deep space. In other words, for the purposes of this presentation, anywhere beyond the moon and anywhere that incurs what might be called a significant time delay. And the third premise is that on the basis of Einstein's special theory of relativity, yeah, nothing can travel faster than the speed of light, including radio messages, which would be or laser communication or radio communication between Earth-based entities and those in what could be termed deep space. That has an impact on the operation of the law generally. So if I could just move on to the next slide. Thank you. The background to this particular work was an article I wrote in 2022, and it was ultimately published in 23. And this related very narrowly to the practice of cross-examination in what could be a form of investigation between an Earth-based entity, theoretically, and somebody in a place in deep space that incurs a significant time delay. And for those who may not be as familiar with cross-examination, it's a tool that's used extensively in the common law world. I'm not entirely sure how it is in systems with inquisitorial modes of investigation for trials, but in common law countries, it tends to be the mechanism whereby evidence is taken from witnesses. And there's a quote there from famous English judge Lord Denning on the nature of cross-examination, and that is that it lies in the unbroken sequence of question and answer. If there is any kind of time between the question and answer, that will give a witness valuable time for thought before answering a difficult question. And if you could just go to the next slide, and just for illustration, on the slide behind me, you can see if there was any kind of questioning between somebody based on Earth and somebody based on Mars, let's say, for argument's sake, which can be at its furthest 22 minutes away at the speed of light. The question would take 22 minutes to get to Mars, 22 minutes to get back, which isn't ideal. And if I could have the next slide, please. So if anyone out there is a fan of A Few Good Men or Codice d'Onore, as I believe it is called in Italian, I want the truth, 22 minutes, you can't handle the truth, 22 minutes back. Yeah, it's not an ideal situation, and it effectively undermines the whole purpose of cross-examination as a means of gathering valuable evidence. So if we could move on to the next slide, please. So the presentation today is based on the follow-up article, which is the speed of law faster than the speed of light, which is forthcoming in the Mississippi Journal of Space Law. And the article explored how this factor might impact in other substantive matters rather than just narrow procedural ones as regards deep space missions and communications between Earth and those in deep space. And the conclusion was that, yes, it has got the potential to affect this in many ways. The solution, well, the conclusion was that a comparative law approach could assist in ascertaining some form of a common legal framework which may offset potential injustices, ex ante lawmaking, or at least some ex ante guidance before any such ventures are attempted, was held to be the the best way of doing this. So if I could just move to the next one, please. So in terms of the areas that were found to have been impacted by this time delay factor, I broadly identified two areas. The first one would be public law matters, such as the promulgation of statutes and legislative enactments, even criminal law to an extent. And then secondly, more specifically, private law matters, in particular contractual matters. The study was by no means exhaustive. Many more areas than this could be effective, I think, theoretically. I think with this kind of thing, it's quite an interesting idea to play around with. And you can think of all kinds of situations where the law could be impacted by what is a relatively simple problem. But like I say, the study wasn't exhaustive. In the interest of brevity, I'm just going to focus on two areas, and that is the promulgation of legislative enactments and contract law. So in terms of promulgation of legislative enactments, hypothetical fact pattern, if you want to think about it like this, a legislative enactment may come on into force in the United Kingdom. Let's say it is 12 o'clock, comes into force 12 o'clock midnight, and you've got somebody on Mars who would be bound by the instrument. Does that instrument come into force for the person on Mars at the same time that it comes into force on Earth, or would it be 20 minutes later once the speed of light has actually carried? Details of the enactment between those two respective places. Now, that is the question of the paper. Is the speed of law faster than the speed of light? If it is, then obviously as soon as an enactment is promulgated on Earth, it would instantly bind the people on Mars or wherever they may be, on an asteroid or wherever the location in question is. However, we know that there's a rule found in many legal systems that ignorance of the law is no excuse, as Thomas Hobbes said in Leviathan, and also you've got common law statements. Lord Bingham, revered English judge, also outlines the position there. If we were to take that as an absolute rule, then surely the logical conclusion would be that an enactment coming in at midnight would indeed bind everybody, wherever it was, or wherever they were, because ignorance of the law is simply no excuse. However, is that fair? Is it just? Is it right? And does it lend itself to credible legal legitimacy? If we're going to take a small step into deep space, surely we must make sure that we get off on the right foot legally, so that the rule of law itself does indeed take with it the sense of legitimacy that we would like it to have for the future and for humankind's progression beyond potentially just the limitations of Earth. So if I could just move on to the next one, please. And so, yeah, this next slide basically just says, I think, sorry, just where am I? Lost my. Yeah, so that's just a bit more. This slide basically just says what I've just said. So I think we can just switch past it. And yeah, when I looked into this area of ignorance of the law, well, there are exceptions to this rule. There are exceptions to the idea that ignorance of the law is always no excuse, and this differs depending on the system that you're in. Germany and Sweden have a different way of looking at it. South Africa does. There's been exceptions in the common law as well, in the United States and Canada, and also in the UK. Just back one, please. Sorry. Yes. So, like I was saying, I think there's potentially grounds for some discussion as to the best approach to take for this before any kind of what you might call exploration or any kind of journey which may incur a time delay significant in relation to promulgation of statutes. And I think in line with the theme of today's and yesterday's conference, a comparative law approach might be useful in determining some kind of guidance or some kind of memoranda of understanding or something like that, or some kind of soft law foundation in relation to these potential problems as they may arise. So a comparative study of ignorance, maybe. Just move to the second one. Thank you. So the other area that I'd just like to talk about very briefly is that of contract law. So as may be assumed, anybody venturing from Earth into deep space may be the subject, well, they will be the subject of pre-existing contractual arrangements involving themselves and people on Earth. And new contractual relationships could indeed arise in deep space between these people and Earth-based entities. And therefore, we've got potential problems to arise here too. So I've got a few examples just up on the slide that's on the screen right now. So it could be property matters. It could even be something as mundane as online banking transactions, other financial matters. And also in terms of exploitation of space resources, it could even extend to that if there was to be, I don't know, a space mining company on an asteroid or whatever form that may take. Contractual matters could maybe arise between the people there and those back on Earth, potentially people wanting to purchase any such resources. Let's go to the next one. Thank you. So in English law, you've got areas, I mean, I'm talking about it from an English law perspective. That's obviously my background is as an English lawyer, but in common law jurisdictions, these similar kind of rules prevail. And this is why I think this area kind of lends itself well to comparative dimension. So communication of offers and acceptances in English law is an area in the case law which has been complicated somewhat, and there are various areas that would be troublesome, shall we say, in this context. And in particular, one would be revocations of offers through lapse of time. So an offer that's been made can be said to become automatically revoked by a lapse of time, depending on the volatility of the subject matter. So if you think about a 20-minute delay from Earth to Mars, let's say theoretically, is that offer still valid once it arrives at Mars? What if there's been fluctuations in the stock market within that 20 minutes? What if the value of whatever it is that's being offered has gone down or up or whatever? So that's just one example of a particular problem could arise. There are various others as outlined in the paper forthcoming, as I said. If we could just move to the next one. Thank you. And like I say, there's also other perspectives on this. I'm not going to talk about them too much, but the position in Germany is slightly different even. You can see just about 2/3 of the way down regarding late acceptance of an application. So a late acceptance in German law can be seen as a new offer completely, which is a bit different to the way it works in England and Wales. So a lot of different, understandably and naturally, a lot of different jurisdictions have different ways of approaching these similar problems. And once again, this is why I feel a comparative study could maybe be useful in determining what may be the best approach for these future scenarios may be. Just move on as well. And I'm not going to talk too briefly, too in depth about this, but of course you've got the Vienna Convention on the Law of Treaties as well, which also sets out another way of looking at this area, and also United Nations Convention on Use of Electronic Communications. And as well, one thing that's interesting is this idea about instantaneous communications and how that works in the context of contract law, because is it still an instantaneous communication if it takes 20 minutes to get from Earth into deep space? Well, I suppose it's as instantaneous as it's ever going to be, but at the same time, is that truly within the spirit of what was envisaged when we talk about instantaneous communications prior to such matters arising in reality? Just the next one, thank you. As well, there's other questions. Like I say, I'm only touching on these briefly today, but contracts where you've got maybe clauses saying that time is of the essence, how might that be affected? Also, areas of tort law, Negligence, people advising those in deep space would have to be mindful of the time delay when actually giving advice. That could arise in a medical context, it could arise in a context of financial advice. And also, I did go into this briefly, but criminal law, issues relating to the coincidence of actus reus and mens rea, the physical act, and guilty mind, as it may be known in other jurisdictions. How could that potentially be affected by this area too? So just in conclusion, my findings were that just simply stating that the speed of law is faster than the speed of light isn't particularly helpful. I feel that it could lead to injustices if it undermines the legitimacy of the law just based on a sake of convenience. I feel a comparative study of basic principles in these areas that may be effective would be a very interesting venture, if only for an intellectual exercise as things stand at the present technological state. And ultimately, any findings from such a study could inform something like a deep space legal framework or a draft framework to kind of counter such issues, or at least preempt some of the problems that this factor may cause. How that would ultimately find its way into the law is a question for another day, but it could be a memoranda of understanding between states. It could even be something for the guidance for national legislatures, the nationality of whose personnel are indeed in deep space or possibly at the higher levels. But like I say, that is a question for another day. And just on the bottom part there, alternatively, if there are affairs of a time-sensitive nature, legal affairs of a time-sensitive nature, you might have possibilities of using a brokerage on earth or power of attorney to make decisions for such individuals that may be affected in that capacity. But then we have to figure out, obviously, how the time delay factor would apply to their relationship between them and them. Thank you very much. And just thank you. Yeah. I've just got a few questions at the end that have occurred to me through this work. There's more than this, but like I say, they are in the forthcoming publication. So firstly, should a common legal framework apply to those in deep space, or should all legal subjects simply fall under the rules of their respective earthly jurisdictions? And we leave it at that, leave it up to national legislatures and different jurisdictions to determine, or do we actually try and put something forward collectively? Secondly, where should deep space be regarded for legal purposes in terms of the time delay? How much of a time delay is too much? What is the minimum time delay likely to have any impact? Thirdly, and this goes in line with the Artemis matters, could the 1.5 second delay between Earth and the Moon present any legal issues? This is something I think I'm probably going to look into next. Moreover, should we actually end up with permanent human settlements on Mars, how long before in situ legal authorities effectively take over? And would such authorities be regarded as maybe autonomous zones or special administrative regions? And what would the additional legal implications be in that respect? And fourthly, what might a system of interplanetary private law look like in that respect? Disputes between Earth-based entities and these autonomous regions on Mars or any other celestial body in the context of the time delay factor. So just if we're going to go to the final slide, in terms of articles in this area that I've written, this is a list of them. So it's the forthcoming one in the Mississippi Journal of Space Law, but the other one based on cross-examination was in the Coventry Law Journal. That's already out there. It's on Westlaw. And I've got a forthcoming one in the Cambridge Law Review due out next month as well. And if I just move on to the next slide, unfortunately, I'm going to have to go maybe sort of mid-afternoon, early to mid-afternoon, so I'm not going to be around for the rest of the day, but my contact details are up there, and it'd be lovely to hear from you if you've got any questions or want to make any suggestions or whatever. And that's all I've got to say about that. Thank you very much.
Thank you very much, Alexander, for this original perspective. I think that it is better to leave the questions and the debate at the end of the panel. So I would immediately give the floor to Enrico Buono of the University of Perugia and Anna Marotta of the University of Campania Luigi Vanvitelli. Their presentation is the public-private law divide in orbit. The floor is yours.
Thank you, Diego. Good morning, everyone. First of all, I would like to thank our convener, Professor Zolea, my dear friend Sirio, and the entire organizing committee, Dr. Frattone, and everyone who has worked so hard for this excellent, really excellent 2 days of work. Then again, I must clarify from the outset that both me and Anna find ourselves decidedly outside of our research comfort zone. So please be kind to us, because we have just pursued an intuition, a metaphorical image, and with the very limited time at our disposal, we can only approach this topic through images, metaphors, suggestions. And so we apologize and defer to a possible written work in the future for further exploration of the subject. The metaphor I would like to address is the precession of the equinoxes or equinox axial shift. This is a phenomenon whereby the positions of fixed stars in the firmament, in the night skies, change over centuries due to Earth's movement and shifting axial orientation. Thus, we naively believe that when we look at a constellation, the stars are actually there, but this reality is not truly reflected. Maybe because the speed of light, of course, is faster than the speed of law and also the speed of our perception. So space law, to us, at least to a public comparative lawyer and a private comparative lawyer, seems affected by a similar phenomenon of axial shift. In yesterday's and today's panels, we have addressed many of the motivations behind this phenomenon. And as we already know well, the international legal frameworks behind space law, governing space law, remain entrenched in the Cold War era, mirroring technological advancements and geopolitical dynamics that are from roughly 40 to 50 years ago. I might be stating the obvious, but by adopting a comparative perspective, space law exposes at least two perspective distortions, or I might say two precessions of the equinoxes. The first is what Matteo Nicolini aptly calls the territorial trap, which stands somewhat in stark contrast to what Professor Ricca has called the aterritorial and aterrestrial condition of astronauts. But the condition of space law is instead very entrenched in territorial dynamics, and actually is a terrestrial legal geography that is projected onto the legal framework of space law, or better still, as Matteo Nicolini has said, is an imagined geography by proxy, resulting in a mimicry of terrestrial spatial production through the uncritical application of a Westphalian paradigm in space as the byproducts of a limited set of states whose interests have been projected onto the firmament. This is Matteo Nicolini writing that. And as Professor Stotler has reminded us, also citing Professor Marchisio, international space law has somewhat inverted the order of international law's legal formats and the sources of legal production. It's an anomalous kind of international law, at least in our perspective, where although customs have emerged instantaneously, Professor Bing Cheng has written about instant international customary law in space since the 1965, lawmaking has been dominated firstly by treaties, by what Professor Agostina Latino calls the Pentagon of the UN space treaties, then rather than the gradual formation of customs. Marchisio also has described these three phases in the evolution of space law: the lawmaking phase, the soft law phase, and the assessment phase. This assessment phase is actually where the authorization and supervision of private activities in space occur under Article 6 of the OST of the 1967. But then again, so we are working with this legal construct, and one legal construct in particular seems particularly anachronistical to us, and it's the public-private divide. This divide looks like to us a fragment of space debris that is residing in the suborbital space between the low Earth orbit and the aerospace. A piece of debris we might as well consider discarding in the formulation of a modern framework for space law. In Marchisio's third phase, the emergence of non-governmental actors is exponential. Consider, of course, we have already talked about this in the previous day, but Elon Musk's SpaceX, Richard Branson's Virgin Galactic, Jeff Bezos' Blue Origin. But returning to the systemic taxonomic profiles of this inversion of legal formats, these private entities effectively generate a new kind of customary law, according to Melissa Darkey's fascinating doctrine of attributed lawmaking. This creates a law she defines interstitial space law, which is actually situated within the realms of private and public law. The mechanisms of attributed lawmaking can be described as follows. International treaties are partially interpreted by private actors, assessing how the parties behave, and customs and subsequent treaty interpretation and practice are also developed through a nation's reaction or failures to react to private acts that are attributable to the state. Such attribution makes the activities of private space actors relevant to the development of international space law. Private activity attributed to the state becomes somewhat state practice for treaty interpretation or customary law formation. So it's like private actors acting on behalf of the state can facilitate the integration of rules into law through statal inertia. So it's increasing the significance of attributed lawmaking in a time where multilateral lawmaking is waning and the distinction between public and private actors in space are getting blurry. And so the second perspective distortion, this is also an obvious statement, is the persistence of the Cold War era bipolar logic in the geopolitical projections of space law, despite the necessity to recognize a multipolar world in which an ever-growing number of state and non-state actors are engaging in space exploration. This, of course, leads to what Nayef Al-Rodan describes as the new meta-geopolitics of space, characterized by the dynamic interplay between influential private entities and emerging countries within a multipolar world order. And then comparative law is a tool seldom used in space law studies, and it proves invaluable for identifying these outdated translational dynamics from terrestrial to space law. So we have selected 2 case studies, which of course will be further developed in the written study in the paper, but for now, I can, at least from a public law viewpoint and as an environmental constitutionalist, address certain elements of interest regarding the concept of space sustainability, which was also, of course, treated in the excellent keynote speech by Professor Palladini, to whose works I will actually refer. So from a private law perspective, Anna will instead address the burgeoning space tourism industry and its implications for comparative law, but in the 1 minute that I have left, I will conclude my section just with one last metaphor. I find it somewhat ironic that the first time a hypervelocity collision occurred in space between 2 satellites, not a satellite and a piece of debris, it was between a derelict Russian military satellite, Cosmos 2251, which was a public asset, and a USA-built commercial satellite, Iridium 33, which was part of the Iridium constellation for satellite transmission of data for mobile phones, which is a private asset. So actually it was a collision between public and private law entities. This case is well described by Stefania Palladini in her 2019 book, The New Frontiers of Space, from which I learned that this collision opened the possibility that the second scenario of the 72 liability convention will be invoked for the first time to compensate for the loss of either satellite. But the state will be considered liable only if it can be shown that the damage caused was due to the fault. And in this particular case, the lack of tracking data and the conflicting information about the clashing event gave neither party sufficient evidence to meet the full standard set in the liability convention. So this incident could not be resolved. And this is a great example of why we should take further legal steps to prevent the so-called Kessler syndrome, where Professor Palladini was talking about earlier, this domino effect that could potentially trigger the exponential increase of space debris as such to seal our planet outside of space. And so, excluding domestic laws, which were amazingly treated by Professor Benvenuti yesterday, and the aspects of the variable geometry of international treaties, which are sometimes signed by many parties, sometimes not. So there's this kind of variable geometry. We can address something as international environmental space law, maybe if such thing exists at all. I don't think it could be based on Article 9 of the 67 Outer Space Treaty, of course, but moreover on the guidelines for sustainability of CUPOS. But still, this regulatory framework set by the Committee on the Peaceful Uses of Outer Space is still limited by the inherent voluntarist approach that is inside these guidelines. So this is, of course, something that cannot be addressed by this voluntary instrument. Maybe something more binding is required. One final image, just to conclude and to pass the baton to Anna, is that to me, as a comparative environmental lawyer, it seems like there is a translational dynamic that is similar to what Professor Malaguti yesterday told us about the necessity to move from an international perspective towards a transnational perspective. It's very similar to the phenomenon of climate change. Climate change cannot be addressed with a territorial paradigm. And if on Earth, our judges, I think about the German Constitutional Court in the very famous 2021 Neubauer case that has addressed complaints filed by Bangladeshi and Nepalese citizens. So even the locus standi is changing in climate change law. So if us on Earth are changing our paradigms, our perspectives for addressing transnational issues like climate change governance, maybe space law could try to do something similar and adopt a transnational perspective, which is, of course, something that maybe comparative law can be extremely helpful. And on the subject of sustainability and environmental hazards, which were already treated by Professor Palladini, I leave the floor to Anna and to space tourism issues related to that. Thank you.
Thank you, Enrico. Good morning, everyone. To begin with, I want to thank Sirio for organizing this interesting conference. And I want to confirm what Enrico said. We are a little bit of our comfort zone. He came up with this intuition, and we have tried to develop it over the months. This intuition is about the uncertain validity of the private-public divide when it comes to space law, this new milieu which has its own legal needs and which poses great challenges, both in terms of law and geopolitics. So this divide should not be taken for granted. The assumption is that transplanting legal concept, institutes, categories, the very taxonomy and the legal thinking into the outer space may turn out to be not the best solution when it to deal with the issues arising from this place, because it is made up of new players, and these players seems to be different from the traditional ones. On a geopolitical level, indeed, power rivalries may occur not only between states on the basis of their representation of sovereignty, for instance, but also between a large number, an increasing number of private actors which pursue their interests in this new territory, and who may become the new lawmakers, the new lawmakers and the new poles in a geopolitical terms, in a new geopolitical scenario. Just think of space tourism, this industry that has been growing so fast since two tourists fly to the International Space Station in 2001 and 2002. This new space race is driven by private organization, private companies, mainly American companies, that are trying to give people their moment in space with the aim of replacing short-term flights short-term flights for a few people to longer experience for as many people as possible. However, this industry does not fit into the legal structures of international law, because the United Nations treaties were introduced to answer the needs of a certain society at a certain moment and to handle a certain geopolitical scenario, the Cold War. Now things are completely different. So from a private law perspective, there are many questions and a few answers. For instance, the definition of space tourist, matters of liability when it comes to national activities of people who voluntarily take a risk on the one hand, but that on the one hand, they may be not fully aware of the risk that they taken, or even the possibility for all the people involved in tourism operation to contractually regulate their relations. So comparative law may be called upon to rethink its approach to study legal systems in space, without forgetting, however, that law still in space is a socio-cultural phenomenon. So as a private comparative law scholar who has always dealt with the relationship between Islamic legal tradition and the Western legal tradition, I wonder what is the role of halal-haram dichotomy in space law, permitted and not permitted under Islamic law in space law, and how these may affect the relation between players in space. So if comparative law may be called upon to review its methodology in this new territory, on the one hand, I'd say that it cannot do it alone. There is a need for an interdisciplinary approach, and geopolitics as a method of analyzing rivalries for power or influence over a territory seems to be a good tool, because we could try to think of a combination between comparative law and geopolitics, focusing on the conflicts arising from the circulation of legal rules, both private and public legal rules, and to analyze the conflict that this kind of circulation brings about in this new territory, which is the space. Thank you.
Thank you very much, Enrico and Anna, for your presentations, which I think give us the come dire, makes us understand that every discipline can contribute to clarify the issues which outer space exploration and use will pose. I will give now the floor to Nem of Tashkent State University of Law. And the title of his presentation is a regulation of commercial space activities in the US and the implementation of the US experience in developing countries. You have the floor.
Thanks, Diego Zamani. And as well as I would like to thank the conference convener, Professor Sirio, for their invitation, as well as their team, Dr. Alessandro and Dr. Christina, for a valuable contribution of this conference. So I'm using this floor to share my view, specifically regulation of commercial activity in this space regulated by the USA and implementation of their experience for developing country in the sphere of digital economy. I would like to my focus on analyzing the US policies, regulations, and institutional mechanism, as well as I will also try to discuss about the limitation and gaps. And in the last, I will assess the applicability of that policies and regulations for the other countries. So first of all, the space industry was witness about the specifically its growth is more about the 500 billion in 2022. So it is anticipated to surge by more than 40% in next 5 years. Particularly if we are talking about the space tourism, which is estimated about 3 billion industry. So it means that there is a scope for the startups, emerging companies to participate, and specifically progressive governments who can get advantage from this industry. So if we are talking about the US, NASA is a key player who manage the space exploration. Country recently oversee about the International Space Station, Orion spacecraft, and the Space Launch System for the Artemis lunar program, the responsibility of airspace related science and technology. So the main laws that are totally relevant to these activities, specifically Commercial Space Launch Act of the USA, that regulate the space launch activities like licensing for individuals and entities which seeking to launch their vehicles or operate launch sites. Law for particularly law, this law terminate the license on the ground if it is against the public health, safety, property safety, as well as national security. So the other organization that deal is Federal Aviation Administrative, specifically the Office of Commercial Space Transportation, which safeguarding public safety, focusing on evaluation policy, safety, airspace integration, and environment impact. The other organization which is particularly deal the matter is National Oceanic and Atmospheric Administration, which has national security related licensing restrictions on commercial remote sensing from particularly benefiting startups. So the recent modification remove a little bit consideration for tire license, including restriction on synthetic aperture radar resolutions, which is about the global image for artificial restriction space objectives specifically. The other thing which is particularly matter about the National Environment Policy Act, which is also called NEPA, which ensure the protection of public interest, property, and national security during the space activities. If we are just overthrow about the US policies, basically these are emphasize the fundamental importance of the safety, stability, and operational sustainability in space activity by recognizing the escalating threat of debris or specifically orbital debris. They advocate the revising and enforcing debris mitigation guidelines internationally, including science and technology for space situational awareness, as well as data and space traffic management. So the operator must submit a orbital debris assessment plan before or each operations. So specifically, if we are talking about commercial space technology, fall under the US export control law, which safeguarding national security, promoting regional stability, and upholding human rights in the space. So company which are engaged in the development and trade of space technology are obliged to getting the adhere with the export administration regulation, which is also known as EAR, and the second one is international traffic regulations, ITER. So in the next law, the space-based positioning, navigation and timing policy 2021, as per PST 7, which prioritizes the responsible use of satellite system and aim to enhance cybersecurity protection spectrum environment. So these are the few laws that I just go through in a short way. So the other thing is their policies are like mechanism, like NASA's Commercial Crew Program that significantly foster the growth of the commercial space sector, partnership with private industry to achieve safe, reliable, and cost-effective human transportation to and from the International Space Station. So the other program, which is particularly about the startups, are small business innovation research, with its goal of stimulating technological innovation and expert engaging with the socially and economically small businesses. So the main challenges are like we can say the gaps are the proliferation of space debris. For example, there is one example about the European Space Agency. They launched a rocket in 1995, and that is returned back after the successful their operation in the mid of this month. So it is definitely a main issue about the space debris. The second is resource conflict between the different countries, different organizations. The third one is commercialization. The other one is evolving landscape of international space law. Specifically, I will mention the last day speech about the Professor Mario about the transnational law, and I'm totally agree because we require strong laws to activate or to regulate all these activity. The other one is space jurisdiction and governance. So that is like required for all these activities that are surging in a future. So in my conclusion, this regulatory discord not only hamper the efficiency of obtaining license for the activity and satellite and luminous development, but also poses considerational challenges and addressing liability concern related to accident or space debris. So the absence of national space law has created a regulatory void, hindering the development and harmonization of robust framework for flourishing the future of the commercial space sector. So thank you very much.
Okay, now there is the final. So Diego Mauri, Outer Space and Hybrid Warfare and International Law Analysis. Diego Mauri is from University of Palermo, and the floor is yours.
Thank you very much, Mr. President. And I also thank all the organizers, and you in particular, for this great occasion for me to discuss this topic. And I start by saying that yesterday afternoon, there was it was argued that there are dark and bright sides with professor of law. And today, if I may add, I will touch upon the issue of whether law does create gray zones in outer space. And I use this term gray because of is part of the military jargon when it comes to hybrid warfare. And outer space can be viewed, can be seen as a domain in which hybrid warfare can take place, actually. So for today's intervention, for my intervention, I will take 3 steps, let's say. First, I will provide you with a working definition, accepted definition, provided that there's one, of hybrid warfare that can be used also for the debate later on. Second, I will try to apply this definition to outer space and to activities that have been taking place in such domain in the last years. And third, and finally, I will test the adequacy of existing international norms to cope with this reality, pointing out also some emerging trends that have been unfolding before our eyes in the recent years. So what about the concept of hybrid warfare? We can start by saying that it has literally exploded in recent years, at least from a decade now. Some would argue that it's always been there. Let me quote, "The supreme art of war is subdue the enemy without fighting." This is not US DoD military manual, but it's Sun Tzu, The Art of War. So maybe the idea of subduing an enemy without using kinetic conventional force, but through other unconventional means has always been there. So the inherent feature of the notion of hybrid warfare is targeting the enemy through means that fall short of war in a conventional meaning. And now let me quote for a more recent document, NATO branded one. Hybrid threats, it's from 2023, so quite recent. Hybrid threats would be coordinated and synchronized action that deliberately target the systemic vulnerability of democratic states or institutions in order to reach strategic goals and create the desired effect. So little to no surprise that the concept of hybrid warfare is now it's now blossoming and experiencing a period of renewed success, especially in Western European states and Atlantic states. As a matter of fact, the institutional framework in which it was unearthed is the NATO in 2010. And back then, what states had in mind was terrorist attacks by non-state actors, both on Western soil and abroad. The concept then rapidly evolved to include also destabilizing activities conducted by state actors, not non-state actors, namely the political opponents, the diplomatic opponents of NATO states. It began with Russia, especially in the aftermath of the 2014 invasion of Crimea, and it continued right on with China. Many activities would then fall within the scope of hybrid warfare. I would quote some: cyber attacks against critical infrastructure. Please remember the distributed denial of service, the DDoS attack against Estonia in 2007. Disinformation campaigns, for instance, in relation to political elections, the boost of migratory routes, and here we can recall the 2021 controversy between Belarus and Poland and the EU at large. Illegal, unreported, and unregulated fishing, the so-called IUU fishing, on the high seas adjacent to the state's exclusive economic zone, another instance of hybrid warfare. So a multifarious bunch of activities, to the point that some argue that hybrid warfare will be nothing but a catch-all phrase or a buzzword, all-encompassing, on condition that it applies to activities conducted against Western states and not vice versa. But if we stick to this definition, the number and the size of potential hybrid attacks is such that they can really destabilize NATO states. And the most legal logical conclusion that international lawyers cannot escape from taking is the one elaborated in 2016 at the Warsaw Summit of NATO. The alliance, and I quote, "and allies will be prepared to counter hybrid warfare as part of the collective security system. The Council could decide to invoke Article 5 of the Washington Treaty." So NATO states expressly declare that the hybrid attack may amount to armed attacks as per Article 5 of the treaty, whose natural consequence could be full-scale military response and ultimately, to say this more trivially, war. This position has been restated in even clearer terms in 2022 in the NATO strategic concept. So there's a lot to discuss about. Once the contours of hybrid warfare and the legal implication that this concept has are clarified, we can now move on to the second point of my intervention. So can hybrid warfare actually take place in outer space? I think yes. The NATO thinks yes also. I mentioned a moment ago the 2022 strategic concept. Here, paragraph 72, we read that hostile operations to, from, or within space may qualify as instances of hybrid warfare. Needless to say, the armed conflict between the Russian Federation and Ukraine was the bench test for such a use of the concept of hybrid warfare in outer space. The military contribution, the commercial constellation of satellites, I name only one, SpaceX and the Starlink service, were given to the Ukraine campaign was well known to the Russian Federation when in October 2022, the diplomatic representative of Russia at the United Nations General Assembly declared that Russia would consider those satellites as quasi-civilian infrastructure, which were eligible for military targeting. So it's the obliged consequence. Kinetic and non-kinetic responses could be anticipated back then. The US representative said that any attack against that infrastructure could be met with a response by the United States, clearly. So this is just an example to illustrate that outer space displays characteristics that are suitable for the components of hybrid warfare. I quote some. The presence of a variety of non-state actors, and here I'm just repeating what has been told yesterday and this morning, private companies, in addition to and often in competition with state actors, and outer space is congested, contested, and competitive, and I quote a very famous expression. Second, the presence at high rates of military sensitive technology, well, again, satellites, and Diego told us before, in international humanitarian law terms, this means dual use objects that can be eligible for military targeting. And third, the usability of non-kinetic and covered means to disrupt and neutralize relevant assets. So let me just expound a little bit on this third and last feature. All the issues associated with anti-satellite weapons have been already touched and probably will be explored later on by other presentations. So I will not get back to them. I will not focus on them. Clearly, the physical disruption of satellites, constellation, mega constellation has a nefarious impact on the space environment and the sustainability of space activities at large, as already been said. I would even dare say that those may be easy cases from the international law standpoint because we can easily find relevant applicable norms, and gray zones are there still, but are easier cases. But one can imagine more sophisticated and anonymous way to reach similar analogous effects. Cyber attacks on Earth and space systems against SSA infrastructure, for instance, electromagnetic pulses, directed energy, so-called electronic warfare, which is non-kinetic by nature, or malicious ADR/OOS systems, the active debris removal systems, or on-orbit servicing systems, so, which may interfere with the enemy, so-called the enemy space activities. So the critical nature of space infrastructure, coupled with the pace of technological advances that allow the user to covertly target the infrastructure, render outer space the perfect milieu for hybrid attacks. And we can expect an incremental resort to hybrid tactics. So I've described so far a concept and say a space, a domain, in short, a phenomenon. I will turn now back to law and where does the law stand? I will be very brief in this and as short as I can. The international community we are living in 2024 is still based on a crystal clear prohibition that was inserted in a UN charter almost 8 years ago. States cannot threat nor use force in their relations. Article 2, paragraph 4 of the UN charter. Only in extreme cases of armed attack and before the UN Security Council steps in, are states allowed to resort to armed force and react in self-defense, which means that force as a means of self-help, that countermeasures in case of international wrongdoing, is not permitted. Those are the cornerstones of the collective security system as it actually stands. We just have an entire spectrum of legal categories in which hybrid activities in outer space must be placed. From the highest to the lowest, we can consider some hybrid attacks, some hybrid threats as armed attack, that is the only one justifying armed force, use of force from the highest to the lowest, use of force, threats of force, intervention in internal or external affairs of other states, that is when a state uses methods of coercion in regard to choices that pertain to domestic jurisdiction, and then mere violations of sovereignty, which do without the element of coercion. So we have an entire spectrum of legal categories that international law provides us with. Admittedly, there are gray zones to the extent that those legal categories, are authors and more importantly, states are not unanimous in drawing lines. It's difficult to place facts in these legal categories. I won't indulge in a long time consuming analysis of each category. I don't have the time to do so, but allow me to pinpoint some general trends, and I will conclude, that have emerged from the practice related to this topic. First, references to the categories of armed attack and self-defense are mounting in the discourses of many, many states. Not only those that are believed to be the sources of hybrid warfare, Russia and China at the forefront, but also and inevitably as a consequence of NATO and US states. To give one instance, and I repeat myself, those states, NATO states' official position is that even hybrid activities could qualify as armed aggression, as armed attack, provided that they are of a sufficiently grave character to qualify as such. And the NATO official documents are quite clear about that. Here, just allow me to recall a position of the NATO, the organization, with regard to cyber attacks, which are instances of hybrid attacks, so we are still there. In 2017, NATO states have declared that the impact of significant malicious and cumulative cyber activities might, in certain circumstances, be considered as amounting to an armed attack. So not just full-scale invasion or giant terrorist attacks, but also the repeated activity that can endanger critical infrastructure, for instance, which is the German doctrine calls Nadelstick-Tactic. I don't know, my German is awful, so maybe I am mispronouncing it, but it's the tactic of the repeated needle, okay? So like something which is ongoing and continuously is provoking on a general scale an effect comparable to that of an armed attack. But this is troubling from the point of view of law, I would say. And it seems that the traditionally high threshold of armed attack is lowering dramatically in recent years. This applies in general and in outer space in particular. So if I had to rephrase this in military political terms, the specter of an escalation, of a military escalation, is now more material today than it was probably 30 years ago. As a remedy, and this is my second last point, some state actors and scholars are seeking refuge not in hard law instruments, the UN Charter, the OST, but in soft law instruments such as the norms, rules, and principles of responsible behavior in outer space. One might say the outer space is experiencing a profound rift between blocks. I use the terms on purpose, but one that, in contrast with the Cold War, which has been already evoked, in contrast to that of the Cold War, is incapable of settling the different stances of these blocks. So my fear is that soft law provisions, which are not binding per se, even if they are, they apply only to a limited portion of spacefaring states, will not be enough. And the ASAT moratoria must be read, in my view, through this lens. But we can get to this later in the debate if you want. Third and last conclusion, and this is really my final point, I wonder whether this is a suitable scenario, not only for the preservation of space environment and human activities of future generations therein, as has already been said, but also for the development of genuinely peaceful relations between state actors on Earth. And this is the idea by Professor Ricca of the ferociousness that Dante saw. I mean, what is this actual situation of our little garden, which is Earth? And I think that the space is now at the center of the rapid and dramatically rapid escalation of military interest between states. So if this is the general landscape, I conclude by saying that applying the concept of hybrid threat, hybrid warfare to outer space without caution, without the caution the international law categories provide, may exacerbate tension to a point that I think nobody wishes for. So we must be very careful when the combination of the hybrid warfare doctrine and the reality of outer space combine. And this is maybe a call for action on the behalf of all of us. Thank you very much.
Thank you, Diego, for your presentation. So this panel was really rich and multidisciplinary. We had the domestic law perspective, the comparative law perspective, the international law perspective. And I am aware that there are several points which are gray and open to debate. And therefore, we are open to questions. Yeah, Franz von der Dunke.
Thank you for that, Diego. It also addresses basically your presentation, although I think the other Diego might have something to say to this as well. You finished your paper, your presentation, with a laudable effort to address the issue of weapons as part of an effort to keep space peaceful, if I may rephrase it like that. My problem is that you avoid the big elephant in the room, which is the question, what is a weapon, right? I mean, it is already difficult enough to define specific parts as sorts of weapons. We've had discussion on anti-personnel landmines, weapons of mass destruction. Do they include laser weapons or not? After 9/11, there was a major discussion about whether aircraft could be qualified legally as weapons of mass destruction in the US context of, liabilities and insurance claims and things like that. So if you now want to make a point, and I see your hesitation as to whether it's legal or illegal, is it not impossible to define a weapon in a reasonable way? Either you define it in a normal way, and then you leave out all the possibilities to use perfectly peaceful satellites as a weapon by just bumping them into something else, or you make the definition so broad that it is not, that it would stifle any peaceful activity in outer space as well. So my question is focusing on weapons not a dead-end street? Should we not rather focus on the use of weapons and outlaw or declare outlawed certain uses of weapons, for example, further to Article 9 of the Outer Space Treaty and the avoidance of harmful interference, maybe things like hybrid warfare or what is an armed attack? In other words, I'd like to hear your opinion. Is this not a dead-end street? Should we not forget about this idea of fighting weaponization of outer space and rather focus on behavior in outer space which would threaten the so far peaceful operation there?
I am well aware of this problem, and indeed it was the object of the discussion I had with Professor De Maestri yesterday. I didn't have the time to discuss the problem of the definition of weapons. Of course, in my presentation, the point is that also this computer could be used as a weapon against you now. So I am well aware of it, and yet I think that we have to establish some limits, and there are some objects which are intentionally produced to cause damage, to be used as a weapon. And so I think that we should clarify this point and to define, first of all, what a weapon is, if it is not clear. And but yes, I am well aware that this problem exists. But in any case, I am really against the doctrine, the literature, which deduces from international practice more than what it can. We cannot say simply that any military use of outer space is lawful because international practice says yes. We cannot always say that yes, it is international practice, so it is lawful. No, I think that we have a precise obligation, a precise duty as professors, as researchers, to say that the states have limits they have to respect too. Yeah. Mm-hmm.
Okay. Maria Elena De Maestri, University of Genoa. I agree with Diego with this, that our task is not only to read the rules and to develop economically activities of states. I agree on that. And I agree what Professor von der Dung was saying, that it's difficult to define weapons. And so it's difficult also to avoid the military use of outer space, because military use of outer space is a reality, is not something that may happen, but it is. So we have to rule something that is already in place. And I also agree, but maybe it's a suggestion that came from Professor von der Dung, and I agree on that, that maybe we can elaborate a little more on harmful interference. That can be the right way through which we can limit the activities, not on the forbid of weapons, the provision of weapons, but well, also on that, but also on what harmful means and the evolution of that concept maybe in future operations in outer space. So.
Hi. So one point for Diego Matbauri and the other point for my former colleague in Dundee. So um, I find the cyber aspects very fascinating. I think probably it's worth elaborating a bit more on the critical infrastructure point because it's really a technical definition that is gaining attention also in standardization bodies. I'm just a bit concerned. I mean, I would hesitate a bit on overcharging NATO and only Western sources. You know, the world is getting bigger, and most states that tend to be very active on the military side in space tend not to be on the Western bloc. So probably looking at their doctrines helps enriching the discussion. Particularly the German one is considered kind of irrelevant in international space because it's neither the US nor really the other side, and it's probably not the best example. My opinion. Alexander, I was just a bit doubtful about calling it deep space rather than outer space if you refer to up to Mars or around Mars, because so far, as far as I know, there's this kind of distinction made in most documents between a sort of outer space, generally spoken, and then a deep space, which is generally considered interstellar. And I think this distinction matters in your case, right? Of course. Also because I think by the time we get to Mars, the communication will be almost instantaneous. I don't think the civilization will happen there before we are able to communicate to Earth in a decent manner. But I do think that, for example, for interstellar travel, if we ever get to that, and for astrobiology, for example, which is a fascinating field, at least for me, and that is interstellar, in that case, I think communications will still be, unfortunately, very, very delayed compared to Earth. So probably this is a distinction that is worth kind of elaborating upon.
Thank you, Ricardo, for this question. And just to set the record straight, I mean, I just put in a German expression, another position of the German government on this topic, which I do not know, but I think that it will be mostly in line with the NATO bloc. And as regards this point, is you exactly captured the core argument that I was trying to elaborate, so that the world is getting bigger. And I mean, it's striking that during when in the 60s, when the main space treaties were signed and ratified, you had a world that was literally divided into two at least. But you can always add the third world perspective and the NAM block. But back then it was possible, and actually hard law was reached because the interest of those at least two superpowers, two super blocks, I mean, they could sit on a table and discuss and reach to say an agreement, a binding law agreement. I think that was a conquest to an extent. Well, today the world is multipolar. Yeah, it's true, and it is bigger probably than we perceive it. Still today, something like that, I don't think is on the horizon in the near future, at least, because and the fact that we are expanding on our attention on soft law instruments. I mean, it's getting regionalized. And I think there is a point that has been cleverly reached also yesterday. And another phenomenon which I'm interested in, and I offer this to the reflection of all of us, are the explosion of ASAT moratoria in the practice of states. So the United States was the first one to say that they were renouncing destructive direct ascent anti-satellite testing. And then literally all the EU followed, other states such as Japan, South Korea. I mean, it's clear those are state actors pertaining to one bloc. And so it's a phenomenon that can be read as well, I would say as a beginning of a practice by state, a regional, say, sectorial practice by state. And I wonder whether those unilateral declarations, which are per se binding if they are a legal binding, if are a legal normative commitment, are giving rise to a practice, but to what extent can we say that this practice is becoming so widespread that binds all actors in the world? Well, I don't think those states that are testing ASAT weapons, that have been testing ASAT weapons, are the United States, and that's fine. Then we had India, China, and the Russian Federation, which are far, far away from that moratorium. So I agree with you. I mean, it's a multipolar world, and what the main difference that I'm seeing from the Cold War period is that at least back then they could reach an agreement, which is still living today. We are discussing Article 4, 3, and one of the Outer Space Treaty. What is going to be the future of these soft law movements? I don't know. I mean, I'm quite skeptical, but I wish I was not, but I am. Thank you.
Hello. Yeah, just in response to that, yeah, I think that's a very good point in relation to deep space, and I did actually put that on one of the final slides as one of the questions that I think should be resolved in terms of what deep space is, in terms of what I'm talking about. Effectively, the definition that I was working on was anything that incurs a significant time delay, and the example of Mars is a given one, and the time that a radio message could take to get to Mars can range from anything between 5 minutes and 22 minutes. So 22 minutes will be when it's furthest away. So yeah, I think that's a good point, and I think some kind of study might be necessary there. I mean, personally, I think that possibly the moon, even though that's like 1.5 seconds away, is that anything that's going to be significant? Well, I think it could be grounds for some kind of speculation. To determine what amount of time delay would actually be harmful in terms of procedure, in terms of even substantive operation of law. Secondly, well, I'm not actually a physicist, but in terms of the speed of light, I mean, Einstein said that, I think he basically said that nothing can go faster than that. So I'm happy to assume that that's going to be the case for quite a long time, unless we master the capability of sending communications at a speed that's faster than light, which, like I say, I'm no physicist, but my understanding is that the state of the art thinking is that that's still quite a way off. I'll take your point about maybe not inhabiting Mars in the immediate future. I would agree with that. However, we could be traveling to other celestial bodies in terms of mining operations or something like that, which may be a bit closer than full-scale habitation. And as I was saying, deep space in the context of what I'm talking about isn't necessarily interstellar space, though I think it's a crucial distinction to make. But anywhere that could incur any potential time difference which would impact on legal proceedings or substantive operation of law. So I would say that maybe anything between 30 seconds and a minute, just as an educated guess, might be enough to be problematic in that regard. I hope that's satisfactory.
Thank you. Marian Aski, Open University. Quick question for Alex, because back in the day, the age of sail, in time of the empire that the sun never set, how did we deal with this issue?
A very good question. In terms of in the past, we would have, I believe, in situ legal authorities. It depends how far back you want to go in terms of the past as well. One of the most common analogies that gets raised in respect of space is obviously the sea and maritime matters, and the way in which legal matters or legal questions were resolved back in the days of states sending boats out on the high seas in terms of exploration and all the rest of it. Absolute authority was vested in the commander of the vessel, effectively. So they were judge, jury, and executioner. But it's important to bear in mind that that to a degree still lives on through the Tokyo Convention in terms of the pilot or the captain of an aircraft having authority to an extent over the mission and everything. But back in the day, the crucial difference was that supreme authority was vested in them. However, as we all know, that was back in the days when there was no radio communications or any possibility of contacting these people. So I don't think that that would be a legitimate way to do things now, when we do actually have some kind of messaging technology that allows us to get away from that. And the other problem with that is, and particularly explored this in the first paper I wrote on this matter, is that if you vest complete authority in the commander of a vessel or a ship in deep space, let's say, wherever that may be, if they are vested with supreme authority, what if a legal problem arises between somebody in their command and somebody based on Earth? The commander of that ship, be they a great leader, be they a great mission specialist, be they a very highly qualified astronaut, is very much likely not to be legally qualified to be able to resolve that particular legal dispute between the person in what may be termed deep space and the Earth-based entity. So unlike people on the high seas, that wouldn't be a good analogy to draw, or it wouldn't be very helpful in that context to say that the commander has absolute authority over every single legal matter. And I'd just quickly like to add about there's an overlap between this kind of thing and diplomacy, in the way that diplomacy used to be many years ago, and we didn't have radio communications or anything like that. You would be sending basically messengers between countries to deliver messages to other governments and keep people updated. And that is something that I've found very elusive to find any material on. And I was disappointed not to have discovered more about that in the course of my studies. But I think there's certainly something to be looked at with that to maybe develop kind of models for future practice or something. Sorry if I've gone on a little bit there, but anyway, thank you.
So good morning, everyone. Thank you always, Sirio Zolea and Professor Vincenzo Zeno Zenkovic for hosting us and for organizing this wide-ranging conference and for sure explorative conference on space law. And I have the dual role of moderator and a speaker. So I would like to follow the program and be the first speaker, and then leave the floor to others, just to make everything clear. So the title of my speech is about the exploration of outer space resources, a perspective on accords and new governance. Of course, the extraction of space resources is not a philanthropic theme. It's not about security, resilience, sustainability that we heard yesterday. It's about profit-oriented purposes. It leads to commercialization. So this is obvious. So the premise before hypothesizing a new governance is knowledge that space resources can be very valuable for sustaining the ongoing operation and future operations, for establishing human settlement, and of course for supporting life on Earth. So moon, asteroids, and all celestial bodies are rich in water, minerals, and such as platinum, nickel, and my most important resource is for sure the water, because as you know, can be converted into oxygen and hydrogen, which combined can make a powerful rocket propellant beyond the use of supported human colonies. So the propellant is quite important because it means that it won't need to be taken from the Earth's surface and transported throughout the solar system. So it's going to be an enormous saving of economic energy and more. Of course, there are also many warnings, many concerns about the sustainability, responsibility, about the incident, about the fact that inevitably this kind of extraction will create streams of debris, etc. But I've tried to focus attention as much as possible to a perspective on accords, because otherwise, it's so big, this kind of argument, this topic. So what is the state of play today? What is the current existing regulatory framework? No international regulation is provided, a very weak and international framework, many roundtables as today, like today, some proposals, some municipal laws. It is very important for me. I think also some fruitful, I would say, accords, even if they seems they are not very important, I would say that they are very important. So therefore, many questions are hanging in the balance. So is it possible to precisely define a right to resources, within which boundaries and under which conditions can space exploitation missions be started and carry on? So of course, many other questions. But let's try to define, answer this. So which is what answer? There are no answers to this, just proposal, I mean. So the Outer Space Treaty is the main international law to look at. We have been saying that. So but it's very important to say that it refers to the use and to the exploration of outer space resources, but there is no reference that to exploitation or to the commercialization, of course. So the only indirect reference to exploitation is contained in Article 2, whose interpretation is well known as extremely controversial. So yesterday we heard the professor Franz von der Donk. I just take the benefit of this, take advantage, and I assume that you already know all the debates around the interpretation of Article 2, even though anyway, the professor yesterday was very interesting in his talk because he clarified that the main problem it goes around the interpretation is if the outer space belongs to all mankind or to global common, can be in different interpretations. It was very clear. So I assume that these points can be well known, but I mean, just to go ahead, because the problem is that it's very important. The starting point is the observation that although some international scholars do not want to admit the legality of commercialization because the Article 2 that ban any kind of appropriation of sovereignty, etc., we are here to discuss it because some states were not intimidated by this article. On the contrary, they wanted to resist it, interpreting it in their favor, making therefore a form adaptation to the law. So thus, there have been various national laws on exploitation, and the US one was a trailblazer in 2015, and Luxembourg, the United Arab Emirates, Japan, Slovenia, you're going to say something about the Slovenia followed suit. So moreover, the solicitation by private inventors was decisive for enacting the laws on space resources and is still pivotal today. In fact, the US law, the Commercial Space Launch Competitiveness Act 2015, in particular, was boosted by two American companies, Planetary Resources and Deep Space Industry, to develop their space missions to harvest water and minerals. And it is a clear exhortation to US citizens to invest in space missions. It's a quite a remarkable aspect that nations, private entities are acting the main role. So, I mean, it would take us also another hour speaking about this thing, but I mean, let's try to move ahead. So the intent of a US law, as well as the other, as that of others, is to legalize the exploitation of space resources, setting few rules, but achieving this goal requires a partnership on which all nations are keen. So it's very important, they understand that it's very important to be more. So in this field, it's clear that the bigger you are, the more you represent, the more power you have. So even you are high states understood that. So it's extremely important that all the municipal laws and the bilateral accords elect states as the main interlocutor is in international dialogue, even though the economic power and efficiency of private investors have rocketed and have altered the boundaries between public and private law, as we have already heard. So the relation between private power and public power is resolved internally, only internally. So therefore, it's necessary to recognize the leadership of many private entities politically and economically. So, but we need also to outline that the Article 6 of the Outer Space of Treaty indeed boosts this ruling, establishing that states party to the treaty bear international responsibility for national activity in outer space, whether such activities are carried out by government agency or by non-government entities. So it's quite important. The responsibility and control are strictly tied to our register system. In fact, all municipal laws are focused on offering a registration system able to identify and control and supervise all current and future activities. So states must have control of all programs and missions undertaken, either by public entities or private enterprise. And they must comply with some prerequisite of securing a license. Anyway, I would say that this is the first stage. To reach an international regime, space economy required a centralized system able to track osmotically all the players in action. And this international regime cannot be achieved through municipal laws, obviously. But it's very important, however, it's very important that the laws mainly are a way to gather international political consensus. That is the basis to have an international legal consensus. So that's why we must not underestimate the value of these national laws. Nevertheless, a projection, some hypothesis of system settlement and management of space resources can indeed be grasped in bilateral accords that are in progress. So bilateral accords represent a second stage, I would say, of this path, which aspire to international regime, represent a design of a new governance, which relies upon different actors working together in no hierarchical networks. So it's very important. They manifest themselves, of course, in different forms and from different sources. I would like to mention some and the outlines that what is for me are more important. So the Artemis Accords that we have been speaking about since yesterday is very important because it was the ones led by NASA and established in collaboration with Australia, Canada, Italy, Japan, Luxembourg, United Emirates, Arab Emirates, and UK. It's very important. But even if they have with this Artemis Accords, the aim is of giving international to sustain a program, a mission to Moon, to be followed by missions to Mars, of course, because the Moon is the first step to reach Mars. Anyway, the aim, the main aim is giving international validation to municipal laws. So the real goal is to provide strong support for the US position that OST, the Outer Space Treaty, does not preclude a sort of property rights over extracted resources. So what is they are looking for is just gather as soon as much consensus about this, because we have to bear in mind that the US law promotes the exploration and collection of material extractive for commercial purposes by United States citizens. But the most important thing, this law grants them the rights to detain, possess, transport, sell, in accordance, of course, with the international law that we are really to understand which are the international laws. So the reference in the US law is not to the right of property, but to all its entitlements. So it's quite curious as to manage this anyway. So going back to Artemis Accords, it's extremely important to say they are extremely reliant upon the engagement with the commercial partners, and they really have the aim to, even if they are not legally binding instruments, they represent a political understanding, so a slow building of the basis to move forward. And we have many other projects, as we have the ones put in place by China and by Russia. And in 2021, they officially announced plans to establish a permanently inhabited base on the moon, the International Lunar Research Station, formally inviting also them, inviting other states and international organizations to become involved in it. So their relation and space cooperation has mutated actually into a comprehensive strategic partnership, maybe obviously I would say against the US dominance, but I think there is something else anyway. So I have to mention the United Nations Corpus Working Group, of course, the International Academy of Astronautics that has established the project group on building an international legal and political regime for the exploitation and use of outer space resources. So there are many initiatives. But every hypothesis of international regulations seems to start from a clarification of administrative aspects, so linked with license and authorization, and any entitlement on the resources seems to come after. In fact, most all relevant initiatives and platforms that have emerged dedicate many rules to organization procedure, listing prerequisites for securing a license, which involve demonstrating the capacity to carry out the proposed plans. On my point of view, whatever the regulation is, it needs to face the issue regarding the nature of the entitlement of space resources. We cannot escape from this. So that should be dealt with in parallel with the issue of common heritage of mankind, that is the legal nature of space. About these issues and among all the initiatives, I would like to outline the remarkable one was taken by the Hague International Outer Space Resources Governance Working Group that delivered the building blocks comparatively recently in 2019, and then again with some modification. But anyway, the working group which delivered this important work was composed of members and observers from government, industry, university, and research centers. So, of course, the view and the perspective is quite wide. And it addresses all the matter from the general to the specific. So but it goes beyond the two main themes, that is authorization and supervision, because we always think that the most important thing is the authorization and the supervision. It goes beyond. So it's very important it's well worth highlighting. So on my point of view, the provision number 7 that identifies and analyzes the priority rights that are not exclusivity rights is an interesting proposal. It embraces both prospective and exploration rights, so the rights to search for and the rights to recover space resources for a minimum period and for a maximum area upon registration in an international registry and provide for the international recognition of such priority rights. I think it's very important. This is attempt. I mean, we have to admit it is attempt, but it's a good attempt anyway. Try. The attribution, duration, and the area of the priority rights should be determined on the basis of the specific circumstances of a proposed space resources activity, with the aim of taking into account a certain degree of protection of rights. So it seems an invitation to alter the traditional legal nature of the rights to goods, and it would lead us to presume and accept a new attribution of a space and natural resource. For this reason, this sense, the framework of outer space as res nullius is not satisfactory, or as a res commune, likewise, we have to find a new framework. However, conceiving a more flexible vision of right to goods does not mean with less rigor, but with variable parameters, albeit previously identified, of course. So in this scenario, I'm just at the end, I'm just arriving at the end. So in this scenario, under construction, the last challenge would be enhancing the capabilities and the potential of a space agency like NASA, JAXA, European Space Agency, in addition to China National Space Administration or Russian Space Agency. They have the potential structures suitable to embrace the difficulty of multi-level governance coveted. I finish with this. I hope that I respected the time. Thank you. Now, go back with the other role. So I will follow, and I will follow the program, and then at the end I will leave some space for thoughts, comments, and of course questions. So I leave the floor to Riccardo Vecellio Segate, from a postdoctoral researcher from the University of Groningen, who will speak about cybersecurity. So the attempts of find a regulatory framework of cyber operation in outer space. Thank you. Thank you.
Thanks, Valentina. Thanks for having me. Thanks to the organizers. Also, thanks to the few survivors in the audience. This work, I'm actually affiliated with the University of Groningen right now in the Netherlands, but most of this work traces back to my time at the Alan Turing Institute in London. And it mostly, I would say, also draws on my own standardization experience at IEEE, exactly in this field. So in the field of cyber safe systems for outer space operations. And to my research experience in China, indeed, at Tsinghua, and also Hong Kong, in Macau, and so on. So what I will be presenting today, it's a bit hard to keep looking at in that direction, but anyway, is a sort of proposal on a regulatory framework for these safe cyber operations in outer space, and also the importance of involving, which doesn't mean agreeing with, but involving and involving seriously and kind of possibly genuinely actors like China in the construction of these frameworks, especially through the channel of international standardization. So the security by design of cyber systems, of course, encompasses that of communications and operations, outer space to Earth, the contrary, and also different combinations thereof. It's becoming a very urgent priority. There are many more missions than before, which means more cyber attacks. The world is moving from security through obscurity to the fact that there is a proliferation of private and public actors, mostly through private-public partnerships. Satellites are being attacked or are on the way of being attacked via radio frequency interference, jamming, replay, tampering, denials of service, malware, spoofing, and you can name it. Also because, of course, they are the dual use object by excellence, which testifies to the blurred lines between civilians and military attacks in general, but particularly when it comes to satellites. And the outer space, as we have heard, is becoming a sort of new terrain for hybrid and asymmetrical and by proxy or whatever it is, information warfare. So we have to account for this. State agencies are being set up to counter these threats in between these civilian and military interfaces. And if you look at the doctrines of states, especially in East Asia, there is an interesting turn from peaceful to non-offensive, which is not the same thing, which means that state agencies are positioning themselves more and more on the high guard. We don't want to attack, but we are very, very wary of the fact that this is going to happen possibly very soon. And of course, this is all happening against a backdrop of segmented globalization or even decoupling along supply chains. Some of those are of interest for space and cyber systems for space. We also heard thoughts about, the big conflicts, next big conflicts probably being fought in space, and so I will leave it there. My research questions. Let's say there are three. They're very interconnected, so I will address them separately here just to be briefer, but in fact, they're very, very interconnected, especially in the paper. But anyway, the first is, can current international legal frameworks, both cybersecurity and outer space frameworks, ensure the security of cyber systems in outer space, currently as they are? Second, what gap-filling role should international standardization play? And third, why does China's domestic cybersecurity framework matter to this end? So let's start with the first, international outer space law. We have heard a lot, so I'm not going into the details. We have realized that it's too vague, of course, it's outdated, it definitely cannot prevent space weaponization. The latest attempt to discuss about this, particularly also interest to me, of course, for this paper is in cybersecurity. So there have been some references in the latest UN ODA open-ended working group at the United Nations, which turned into the usual principles of responsible behavior. When it comes to cybersecurity, they did mention a few things, the usual stuff about difficulty of attributing cyber attacks and the usual things that we have heard for, I would say, 20 to 25 years. No advancement at all, okay? Neither doctrinally, even less legislative or practically. UNIDIR, as we say in Italian probably, has issued a policy glossary, which is obviously even less binding. And the problem for me is not only about bindingness, because of course soft law is advancing and filling many gaps and so forth. The problem with me is that, again, only very cursory references to cybersecurity, let alone technically. It's the usual restatement of the very big problems, but there is no advancement at all when it comes to technical details. Probably it's not even the right forum, and that's why I will argue about standardization. International cybersecurity law instead. Well, the UN process is another stalemate. No treaty definition of cyberspace, cyber operation, anything of that sort. Of course, we have chapter 10 in the Tallinn Manual 2.0, but that's only a scholarly output. And also it's very NATO-sided. We have to stop thinking of NATO as the globe. The Tallinn Manual has been almost, has become almost a source of law in many discussions, but I think this is really wrong. The Tallinn Manual is a very good source. It has been written by leading experts, but they are Western, and they do not represent what's going on in the world. Chapter 10 is about cyber operations in outer space, so it's very interesting, but it's a work of scholars. Customs, of course, necessarily in progress. We have heard about instant customs in international law. Of course, they are called Gaussian moments, but I wouldn't go into that for practical reasons. And internet governance itself, which is relevant, of course, in this particular debate, is mostly a loose multi-stakeholdering exercise. So nothing of help from international cybersecurity law either. General public international law. UN Charter on the use of force. We have, of course, we possibly have some more from international humanitarian law. The problem with these regimes is that they're all about state responsibility, but they are not helpful to design cyber safe systems by design. They address what happens next. They address what happens after an attack. Technically, they also try to prevent, but in any case, they don't mandate, they don't specify the legal requirements to make sure that systems are cyber secure by design. They are not helpful to people in the industry, in fact. Okay, they are only very exposed. And they're also conflict intensive. Now, conflict is a very dark terrain and probably not the most let's say, immediately applicable to all cyber attacks. It's of no relevance for civilian applications. There are a lot of spurious cyber attacks, whose, again, the identity is not incredibly clear. So probably immediate derivation from international humanitarian law is, again, not very helpful. So as we have seen, neither international outer space law nor international cybersecurity law and general public international law either are very helpful, let's say, to design cyber safe systems for outer space operations. What else is going on? Standardization. Because of course, while we wait for lawyers and especially diplomats to try their way and get something done, I'm not saying it's easy, but this is the situation. Meanwhile, the industry, of course, presses because the money is there, the will is there, and the power is mostly there. And when it comes to the industry, the first thing that they do is to go and look for standardization. Now, the latest effort in this space is the IEEE essay that you can see there on Space System Cybersecurity Working Group, which is actually mine. It's divided in 4 segments plus an integration layer, just like any effort of this sort. The integration layer is, of course, about the data bus within the cyber systems. It draws on a call for action, which was a scholarly work, but in any case, it has drawn international attention. And just like any exercise of this sort, it outlines some tension between public service and multi-source lobbying. This is nothing strange, it's just part of the game. How can it help? Because that's the point, right? We are trying to find something that helps in practice to do something decent, helpful. Meanwhile, the lawyers try to, again, continue the debate. It's more technical, which means, of course, it's rapid, effective, specific, and so on. Is a bit less definition intensive in the way the lawyers understand definitions. Of course, there are a lot of definitions that are not necessarily easier, but some of those definitions are so technical that they don't necessarily involve geopolitics, which makes, of course, the work of standardization agencies and bodies much easier than those involved where lawyers are involved. And of course, it's more process oriented. Now, of course, standardization is not a panacea for anything. It also has its problems. It was supposed to be a truly global endeavor, voluntary, so just private self-regulation. It's supposed to be non-partisan, policy neutral, politics free, made of engineers, computer scientists. It's not necessarily the case. In reality, even historically, if you look at London, even from the International Electrotechnical Committee founded in 1906, it has been a voice of the empire. Okay, so of course, it has transitioned from mostly the UK to mostly the US. Today, it's, I would say, mostly an Atlantic tool, which means that it's mostly about Canada, the EU, Japan, South Korea, Australia, regrettably also Israel. But in any case, it's still US-centered. This is the key point, especially if you look at where people actually studied. Of course, some diversity is being introduced. For example, if you look at East Asian jurisdictions, but the key point is not the nationality. The key point is where these people have got their training. And if you look at the people who are there, most of them come from the top schools in the US. Is it a problem? Might be. I will outline that it might be for some reasons. And its standardization has long been a channel for political and commercial dominance. If you can only think about standardization patents, for example, they are built on standardization efforts. So they tend to create winners and losers geopolitically. They are also factually binding on industry and imposed on market players, so they are not voluntary and they're not self-regulation. I mean, de facto, okay, de facto. They are defense heavy, so even when you try to do something civilian, in reality, what happens is that defense steps in very, very heavily, which again, drives these efforts a bit far from probably their original barycenter, and the ground claim of technical superiority to also military might. So there are a few shortcomings. They're not jurisdictionally inclusive, so they tend to ignore large fractions of the globe. They're not policy aware, so they tend to be easy to misappropriate from policymakers because these people are not very aware, the standard makers of the policy implications. They're only technical, which means that it's not immediately easy to make them policy interoperable, so to make them readable to actors that are different from industry and technical people. They're not necessarily legally savvy, which means that there is limited room for enforcement beyond very technical disputes around safety. Again, they are regulatorily captured by the defense, and they are a bit excellence by bias. By what do I mean by that? Technical standards need to work, and to work, they also need consensus from a lot of, let's say, different social legal cultures, and this is where the focus should be. Technical standards are not a scientific pursuit; they are a technical one, which means that they don't seek an absolute excellence. They are not. It's not based just on merit. What they should aim at is to work in practice. And again, one necessary step in order for them to work in practice is not to seek excellency by default and as an absolute, but is also to find minimal compromise with what states would accept. If states don't accept the actual outcome, technical standards might be excellent or even the most excellent from a scientific perspective, but they fail their stated aim. So that's why there is some salience in a more inclusive, as sensitive and informed process. I would say that lawyers should also be involved from the start, especially at the scoping stage, in a way to make these standards more enforceable. It's also a matter of collegial, let's say, epistemic resonance with the judges and the regulators, and then we look at the standards in order de facto to solve disputes. If lawyers are involved by design into the standardization processes, it's more likely that the language of these processes, of the outcome, will resonate with those who will need to use the outcome, legally speaking, which means judges, arbitrators, and regulators even more. So what's China's contribution in this? So I'm at the third step. First, of course, it's the main contender to the US for the international disorder. It has a very ambitious space program. We all know it. It is within a very competitive region in space, which means India, which means the Republic of Korea, so South Korea. It means especially Singapore, I would say, though in smaller dimension, but compared to that, it's very strong. And also, this is the claim that you will find most, I would say, controversial, and I understand that. It has an extremely mature and innovative cybersecurity regime to look at. I will defend this claim very soon. And it is very active in ICT standardization, often in opposition to the West, this must be said, also through the Belt and Road Initiative. Why? Because, of course, a component of the Belt and Road Initiative is the digital Silk Road, and what they do, of course, is infrastructure, also digital, and in order to enforce the infrastructure, you need contracts. In order to enforce contracts, you need interoperability. In order to have interoperability, you need to socialize standards. That's why China is very interested in standardization, especially in the digital sector and especially cybersecurity. There are even official programs sanctioned by the party in China about this, and there are even, let's say, blacklists about the standardization body that Chinese should not, or should preferably not, collaborate with. So as you can see, we are going down a very dangerous path, because what my claim is basically, we only have standardization left. If we lose also standardization, there will be no communication at all between the main powers in practice to agree on minimal standards to have some decent level of safety in outer space. So if we lose also collaboration in these settings, I'm not sure we are going any further in the debate, or at least in the practice of security from a cyber perspective. So China and international standardization. For the longest time, it has been excluded as periphery. Today, its new status as global power is, of course, acknowledged, but China is still excluded. Often, of course, because it submits proposals in association with Russia. Think about all the Shanghai Cooperation Organization proposals with Russia, also about cybersecurity. And of course, for us, this is problematic. This is problematic. But we like it or not, China and Russia are two major superpowers in space and in cybersecurity. So whatever we want to do, we need to find something with them. I mean, this is a very straightforward and very basic claim, but this is the reality. So in reaction to this exclusion from the major circuits of international standardizations led by the US, China is, of course, proposing its own alternatives. And this is already going on. So as I told you about the unwanted standardization bodies list, and it has its own, of course, alternatives that is trying to build, especially through South-South cooperation, and especially through programs like the Digital Silk Road that I mentioned, with major actors like, for example, Brazil, and I won't mention more, but this is the situation. So what is the added value? if you look at China's contribution in international cybersecurity, it's not very helpful, okay? Because the emphasis in usual things, sovereignty, patriotic information ecosystem, all these kind of things, they're not helpful. They're not helpful to our aim. There are also too many conceptual leaps from the international regime, because you have to go from international humanitarian law, for example, warfare, terrorism, and these kind of things, to cyber warfare, terrorism, blah, blah. And then you have an additional conceptual step to make, because it's not only about cyber terrorism, blah, blah, but it's cyber terrorism in outer space. So there are 3 conceptual leaps. In practice, it's too hard. So if you want to understand the potential contribution, you have to look at the domestic cybersecurity framework. And it's extremely promising. I mean, objectively, we must acknowledge that China has done a lot in the field. We may like it or not, we agree or not, that's another step of the reasoning, but we must acknowledge that this is important to engage with. And this is about cybersecurity law, the personal information protection law, data security law, all these kind of laws. They are a very coherent framework, together with the updates to the civil code, judicial interpretations by the Supreme People's Court. As a whole, it's a very integrated and very, very well-formed framework. It's very mature also, and it signals the emerging as a cyber power of China in this specific field. I'm not making a general statement, in this specific field of cybersecurity domestically, and then, of course, we can use it for our aim in outer space. I defended this claim widely, exactly because, the higher the claim, the more you have to defend it, right? So I abounded with outputs in order to make sure that the claim was very safe, because it's a big claim to say that cybersecurity in China is something that Western states are actually looking at in order to transplant to the West. This is something that has never happened over the last, I would say, 300-400 years of civilization, legal civilization. I don't know, maybe the claim, I'm not a legal historian, but in any case, generally speaking, I would say it's very big that in technology, at least in technology regulation, China is an exporter of norms. And I've defended these claims in, so one article is for Columbia, another for UCLA, and 2 of the main journals in the world for Oxford University Press. So the claim now is safe. But of course, it's not been very easy to defend. So last thing I will close with, I will give you an example of what it means to look at domestic frameworks to try to draw elements of interest for the international standardization process, which I guess is the whole point of the discussion. Criticality. So whenever you try to do something with outer space and cybersecurity, it comes up that you need to define critical systems. Okay, criticality is a very key concept in space security. A cyber system is deemed critical if it is an attack surface, first of all, and second, if there is a capability to attack that attack surface. And third, especially if the success of this attack would undermine the mission aim or spill over onto society, humanity, and so on. There is a tension in this field, which is the whole point. A tension between criticality for the mission and criticality of the system. So you can have a cyber critical mission or a cyber critical system, or a cyber critical system within a non-critical mission, or the opposite. So this is a key definitional problem. And it really changes it really matters if you look at one or the other first. For example, if you look at, if you define criticality in terms of mission, then the criticality of the system will be derived from it and will not be cybersecurity specific. In any case, the point is you need to find agreement among states about what criticality means from a cybersecurity perspective. I have already defended the thesis that there is no other better source, so we must look at domestic frameworks. And we have to stop. I'm sorry, I'm trying to be, probably I'm a bit too patronizing in this, we have to stop as if we all do it. But unfortunately, from my experience, we all do this of keep looking only at the usual suspects, so the US, NATO, the EU, blah, blah. The world is getting really bigger. So when it comes to domestic frameworks, we must look at China as well. China, unfortunately for us, Russia, India, Japan, they are essential. We must understand their cybersecurity laws if we want to do anything in this field, in my view. In China, cybersecurity law is essential for understanding criticality. I will just give you, let's say, 2 examples. First, China defines criticality along a multi-level scheme whereby protection is binding, protection of the cyber assets is binding on every. I'm concluding. Yes, I guess I have 2 slides, so this is only the conclusion left. All right, so I will skip this. I hope you. Okay, I will. No, that's understandable. So I will skip this. No. I mean, it's obvious. So I will skip this. It's a very complex presentation, so excuse me for that. I've been trying to speak very fast, but it's still a lot, and it's still very complex. So sometimes I forget things along the way. I will just go. I will just really move to the conclusions and then with them. I will just take, I guess, 1.5 minutes to really go through them at least. So context, weaponization of outer space. We started from that, right? So overcrowded, a lot of unregulated private actors, battlefield for upcoming major conflicts, especially from a cybersecurity perspective. Satellite cybersecurity is becoming, within this context, a top priority, despite there is no appreciable progress when it comes to shared rules and cooperation, owing to some also mistrustful rhetoric. Outer space is too high level a framework. It does not help us. International cybersecurity, it's also known, it's a bit more detailed, to be honest. It's a bit more detailed, but it's not binding. And there is no agreement between the Sino-Russian bloc and the rest. International standardization is trying to fill some gaps. It's a bit faster, it's technical, it's very heads-on, but as I've tried to explain, there are issues of jurisdictional inclusivity, policy interoperability, and let's say trustworthiness when it comes to the output that is placed before the attention of states in order to, of course, states do not technically agree to a standard. Standards don't need to be agreed upon by a state, but of course states look at the standard and more or less formally compel their industries to abide or not to different extents. And again, they're used in court, they're used by arbitrators, they're used by regulators. So de facto, standards play a public role. It's almost it's a quasi-administrative role, the one played by most standards. So to be more policy interoperable and legally enforceable and so on, we need more legal policy expertise from the early stage. I've already explained why. China must be included to avoid friction, prevent as much as possible fragmentation and avert some decoupling. But China can also serve to deepen some expertise, not so much thanks to, let's say, its regional networks of cyber normative efforts, but mostly thanks to the domestic cybersecurity framework. And finally, questions of criticality represent the cardinal example that I think I will defend the most in the final outputs of this work, and will hopefully clarify what wasn't clear through this very, very fast-paced presentation. Thanks.
Thank you very much to Riccardo Vecellio Segates. Would be very interesting. I agree to encourage this kind of a cooperation. Take the best, make the most of the capability of each country. Would be amazing. Combines the American expertise in setting technical operation missions, at the same time get the best of China regulation on cybersecurity. Let's see. For sure, it seems the glossary policy is quite important for any sector in space law. So I I leave the floor to Maria Elena De Maestri. She will introduce the new proposal of European law, so the new tentative attempts to reach to have a new regulation. So let's see. I leave you the floor. Thank you very much.
Thank you very much, Professor Barella, for introducing me. Thank you to the organizers of this very beautiful and interesting event. Well, I would love to introduce you to the proposal, but I still do not have it. So it seems that nobody has the proposal. So my speech could be a sort of an empty speech, or on the other side, it could be a sort of prediction concerning what will be issued in 1 month. So what I would like to do is not to discuss the content of that proposal, since, as I told you, I still do not have it. but my purpose is to analyze the need for the European Union to intervene in this sector and the need for a European Union law. So a little bit of backgrounds, not focusing on competencies at least. I will say, let you know why I'm not focusing so much on competencies. And then having, well, a critical approach to what can be done and what we hope will be done. So let's move on. The basis for my intervention is the only thing that we have at the moment concerning the future European Union law, that is the speech of the Commissioner Breton that was also mentioned yesterday by Professor Marchisio. So from the speech, we understand that the main pillars of this proposal will be safety, security, resilience, and sustainability of European Union space activities, and that the objective of this law will be to create a single market for space activities through the application of common rules. So the idea seems to be to have minimum standards for space operations for any space system operating within the European Union, whether the operator or the one that provides for that space activity is European or not. So for everybody that will start its activity from European Union, the European Union wants to have common standards established at the European Union level. So in order to analyze the reasons and the background for that intervention, we have to make two premises that have already been touched by the speeches, the contributions of yesterday's session. The first one that has been recalled by Professor Marchisio yesterday morning is that Article 189 in combination with Article 4 of the Treaty of the European, on the functioning of the European Union attributes to the European Union, so member state attributes to the European Union, a so-called sui generis competence. Well, effectively, on the from the technical point of view, it is a shared competence, so this has to be kept in mind, and I will recall it later on, concerning the principles that are applicable to all shared competence of the European Union. So it is a shared competence of the European Union with the member states, but it's a very peculiar shared competence. That means that the European Union can intervene with reference to the space sector and space activities, but the exercise of this competence cannot lead to the harmonization of the laws of the member states. So surely this means that the European Union cannot adopt directives nor regulations providing for common rules for space laws. It means that at the moment, now, the European Union probably could not, and I will explain why I'm telling you probably, could not adopt a law that provides for all the member states the prohibition of the exploitation of the resources in outer space. This would be a space law concerning harmonizing the national laws. But however, it has to be said that Article 189 of the Treaty of the Functioning of the European Union is not the only article that can rule or regulate the European Union intervention within the space sector. It is clear that space activities are touching different, and it has been said also today, is touching different ambit, different sectors of regulations, not only space directly involved, but also, for example, environmental activities, also defense, for example, security and defense, and all those other sectors are of the interest of the European Union. Obviously, the choice of the legal basis for the European Union intervention is relevant not only because of the type of the act that can be adopted, regulation or directives, it depends on the topic touched, but also by reason of the majorities required. For example, if the European Union decides to act in a sector concerned by the defense policy, then the unanimity of the votes of the members of the European Union is requested. While if you decide to act on the basis of the internal market, for example, that is one of the main bases used for the intervention of the European Union, Article 114, we are going to go back on that in a few minutes, then obviously you don't need to acquire the unanimity of the member states in order to adopt legislation and regulation. The second premise concerns a very well-known topic for international lawyers dealing with space law and space activities. That is the multi-level complexity of space law and of space regulation. We know, and we went in depth in that analysis during these 2 days, that we have multiple actors within the space domain. We have states, obviously, the first who started the activities in outer space. We have nowadays the European Union that from the 1990s declared its interest in intervening in the space sector. We have other international organizations that had a leading role, such as ESA, for example, but many others also. And we have also, as we understood in today and yesterday, companies, so private actors that are, at the moment, the main economic push for space activities, and also we can say for the need for space legislation. It is clear that all those different subjects and actors have different objectives in their action, for their action in space, and different tasks. For example, Marco Ferrazzani stated yesterday that ESA is not a legislative task, but operational task, different objectives, different tasks, and different policies, different laws, different practices, and within every subject, the balance of the different interests that are tackled by space law is made in a different way. Obviously, states have to pursue their internal security, defense interest. Namely, for example, the European Union has different interests than those of the states, and private companies have different interests that lead their action. Therefore, to rule space activities is a very complicated issue. And this is why also we are struggling today of having a multilateral regulation of the new space activities. So let's move back after those premises to the European space law. First of all, it has been said yesterday by Professor Marchisio, presumably, let me tell you, presumably, the legal basis of this, because of the speech of Commissioner Breton, the legal basis of this initiative will be Article 114 of the Treaty of the Functioning of the European Union. So it has been shown by the case law of the Court of Justice of the European Union that Article 114 can be used as an appropriate legal basis for derivative legislation, even when such derivative legislation has an impact on topics that are not attributed totally to the competence of the European Union. It has been made, there are judgments of the Court of the European Union stating that, for example, in a subject such as human health, where the European Union didn't have a total shared competence, but it was limited since the European Union cannot harmonize national legislation, such as it happens with reference to space, the European Union adopted a directive that had an harmonizing effect on national laws, but that harmonizing effect was based on Article 114 of the Treaty of the Functioning of the European Union. So the Court of Justice stated effectively that article can be a proper legal basis for the European Union intervention, but such a measure adopted using Article 114 must genuinely have its objective in the improvement of the internal market. So what is asked to the European Union institutions is to precisely state why it is needed that measure to improve the internal market. So the legal basis cannot be a sort of circumvention of the limits imposed by states to the action of the European Union. It is relevant to underline that the European Court of Justice, the Court of Justice of the European Union, better to say, also stated that Article 114 can be used to prevent the emergence of future obstacles to trade resulting from national laws. So it is legitimate to use that article in order to provide for rules that prevent the obstacles. And it is relevant for space activities because nowadays we still do not know what, for example, the exploitation of resources how will it impact on the national activities and legislations. So why we need a European space law? Presumably based on Article 114, but not only, as I stated. First of all, because we have national fragmentation within the European Union states. And national fragmentation can jeopardize European Union law enforcement. We will see what can be jeopardized. Secondly, because at the moment, we are facing a competition between European Union states' legal orders. So states are coming up with national laws that attract investments from European companies in order to push their economy. That is quite common. It's not, it's legitimate, obviously, but it is desirable within the European Union. And finally, a concept of strategic autonomy. Briefly, I'm going through all the three elements very briefly. With reference to national fragmentation, it is a reality that at the moment we have 11 European Union space laws and they are not coordinated from the material, neither from the personal scope of application. The laws providing for the authorization of space activities of the European member states are not the same because they are driven by the priorities of each member state. So authorization regimes are not coordinated nor harmonized. And as Professor Marchisio reminded you yesterday, merely all the European Union laws provide for their application and then for the authorization of the state whenever the activity starts from the territory of that state, but also whenever the activity starts everywhere, but is carried on by a national of that state. Therefore, national legislation has a potential extraterritorial application to all the activities carried on by their nationals. And this can be an hamper to, first of all, the free provision of services as granted by the European Union treaties. So it is true, and you can read throughout the European Court of Justice case law, that the rights of the European Union citizens and therefore the freedoms of the European Union citizens apply even if a topic is not attributed to the competence of the European Union. We have many cases on that, for example, with reference to the gamble topic. And therefore, it is true also that then the free provision of service rules also apply, so the prohibition of limiting that also apply to those topics such as space activities, space law, where the European Union has a competence, even if that competence is limited. Then, since the space competence is a shared competence, even if limited, general principles of European Union law apply. One of those general principles is mutual and sincere cooperation. So can we state that member states are cooperating sincerely if they do not try to harmonize their own national laws? For example, recognizing the authorization released by other states, other European Union states. Second element, and the last one, and then the conclusions, strategic autonomy. the concept of strategic autonomy is a very abused mainly concept. It is used in the last years for European Union activities within the security and defense ambit. Strategic autonomy usually has to be shaped towards someone, and it is clear within the space sector that the European Union since the 90s is struggling for having strategic autonomy from third states. First of all, from the United States. In all the documents of the European Union, you find the need to be independent, first of all in the 90s with the Galileo project, for example, to be independent from the United States, to be autonomous from other states, Russia, and so on. And now, in the last release, in the last documents of the Commission, you don't find anymore the need to be independent, but the need to be leaders. It is a little bit different. The term leader has been used usually by the United States and now is one of the priorities of the European Union Commission, if you read the statement on the Union of President von der Leyen. So it is obviously external strategic autonomy. But what about a different concept of strategic autonomy? So can we deem that the European Union now wants to have strategic autonomy towards the member states, having its own European space law? Then it seems that the European Union wants to have its own independent not only access to space, but also own independent vision of space activities. Through the programs in an operative way, it has already been done. Through the policy of the European Union, it has already been done. That has been agreed with ESA and therefore international actors. But what about the autonomy of the European Union towards member states? Can it be seen as an attempt to have it? So the conclusion is that for me, in this stage, the task of the scholars is not to just criticize the possible intervention of the European Union through the articles of the treaty, the limitation of the competence, but maybe to look at the European Union as a sort of privileged area for enacting international cooperation. The principle of international cooperation is a basic principle of space law, international space law. It is stated since the first treaties in the 60s. It is stated in the first declaration of the bilateral relations between Russia and the United States. So international cooperation is the key, maybe, to apply the rules of the treaties to new technologies and new activities within space. And so the European Union can have a leadership in that, in enacting international cooperation, because European Union can impose cooperation among the member states through the legislative process. Today, Professor Barella says we have to reach the political consensus in order to have the legal consensus. Well, within the European Union, the political consensus could be presumed, could be reached by reason of having this structure. And then it could be easier to find a legal consensus and then to ask for the European Union to be a leader in the creation of new standards and new laws. Let me say that the European Union as a supranational organization can also take into account interests that are not properly taken into account at national level. Putting together, for example, the topic of the protection of the environment and also the protection of the outer space environment. So it can be taken into account and will be presumably will be done with national standards. Which are the problems left open? And this is a bomb, I think, and we will discuss about that in future. So what about the international position of the member states towards third states and towards international organizations such as ESA once that the European Union starts intervening with the European law? Will the member states still be free of enacting their national policy towards third states, or as it happened in other sectors, such as the maritime environment, the European Union will impose the respect of at least some basic European standards also towards third states. How does the limitation of competence impact in that topic? Thank you very much.
Perfect in time. So thank you very much, Maria Elena De Maestri. Thank you. Of course, the big representative position is a salvation for everybody. As I will say, we have to be as much we are, as much we can have the hope to be heard by someone. So it's very important, really, with the principle of mutual and sincere cooperation. So let's now leave the floor to Marco Falcon, researcher of University of Padova, who will tell us his Roman perspective, for sure, about space law.
Thank you.
Roman ancient, of course, no Roman.
Yeah, not Roman of nowadays.
Exactly.
So thank you. Thank you very much, Madam Chair. I would like, of course, to thank the organizers and in particular our convener, Sirio Zolea, for the opportunity to speak at this prestigious conference in the presence of so many well-known experts. As the chair said, I am a scholar of Roman law and I aim at making a modest contribution to the open space law debate from a historical perspective, hopefully without committing too serious trespass. For evident reasons, so Roman law perspectives, for evident reasons, Romans had no space discipline as we think of it today. It has a set of rules regulating space and outer space activities. So the Roman perspectives are in fact more a kind of retrospective thoughts about space law, and in particular on the 1967 Outer Space Treaty that we all know. In dealing with this topic, I will leave aside some general problems that could be addressed in the use of Roman categories for current law. For example, I will not confront the problem of the alterity between states, of course, main characters of international law, and private persons, which were exclusively taken into account by Roman law. So, as is well known, since with the first space explorations and also before, as we heard yesterday, a question arose. What should be the regime of space and its content, namely the celestial bodies and in a position that has always been special, the moon? And the answers, as I could understand, were initially varied. But it is worth noting that they were all based on principles that in one way or another went back to Roman law, often recalled as source of traditional principles of international law. So left aside the idea that state sovereignty and so lato sensu ownership could extend itself usque ad sidera, so to the stars, some scholars assume that space and celestial bodies could constitute res nullius, so things without an owner, referring directly to a Roman category of goods. According to this indeed very simple theory, outer space and celestial bodies would be assets without owner that could be acquired through simple, let's say, occupation. And precisely in order to avoid the problems linked to this category of res nullius, and first of all, the survival of the fittest, the states in the OST decided in favor of the non-appropriation principle, of course, that may be found in the second article of the OST, as you all know, and is recognized as jus cogens. And according to the vast majority of the scholars, this regime is the regime of res commune somnium, although the expression does not appear in the treaty. So, sorry, I should have done this. Yeah. So Roman concepts, Latin wordings in international law. Also, res extra commercium is very used, of course, from, for instance, Bin Cheng. So looking at the whole matter, we could say that there is some kind of viscosity of legal concepts that pushes scholars to hold on terms and expression taken from our common legal history, especially in cases where a clear discipline is lacking. So as the concept of res communis omnium is drawn clearly and overtly from Roman law, it is interesting to compare its meaning in ancient law to that enshrined in the OST. I will therefore try, mainly for myself, of course, to outline the main features of the non-appropriation principle and then to build a parallel. First of all, the non-appropriation principle is the prohibition of national appropriation, of course, that could be carried out by claim of sovereignty by means of use or occupation. This is very important. These are civil law concepts, use and occupation, or by any other means, to be sure. It seems to be undisputed that the only entities which can carry out a claim of sovereignty are states, but they can also perform use and occupation, as the OST says, just like private entities. In all cases, these behaviors are not adequate to achieve appropriation on or in outer space. Nowadays, as we heard many times in these 2 days, it is also possible that non-statal private entities, Blue Origin, SpaceX, and so on, we already heard these names, reach and use or occupy some portions of, for example, the moon. And international law scholars, I this confirmed, usually agree that this kind of appropriation is also legally impossible, either because private use or occupation would anyway fall under the provision of Article 2 OST, or because where there is no statal legal system to recognize it, there cannot be any private property. So there is not the concept of property. So as many scholars pointed out, and this is also a thing we heard many times, this whole regime could be unsatisfying for our present and future needs because of the abundance on the moon and in many celestial bodies of minerals that are rare on Earth and yet fundamental to many significant purposes, like production of chips, batteries, and technological devices in general. So the situation in the long run could most likely trigger international disputes that will have to be tackled by jurists up to the challenge if states do not expressly modify the OST. And in this scenario, the notion of res communis omnium has perhaps not been exploited to its fullest extent, so that before setting it aside, a closer look from the perspective also of Roman law might still be useful. This is of course, a proposal. So, Roman law, briefly. Martian, a Roman jurist who lived between the 2nd and the 3rd century AD, tells us that, according to the natural law, there are things common to all, so res communis omnium, of course, others that belong to a community, so a littler community, some that belong to no one, but everyone can appropriate them, these are res nullius, others that belong to individuals, who, according to various mechanisms, can acquire them. Of course, there are the things we all know in our everyday life. The same jurist, so Martian, the second source, draws up the list of res communis omnium and tells us that they are the air, the flowing water, the sea, and per hoc, so hence, a very complicated expression, the beach. The single items enlisted demonstrate that a thing is communis omnium when, while not being appropriable as a whole, it can be appropriated partially or pro parte, or if one prefers, that the thing enlisted is communis omnium in its natural status and falls partially into the property of an individual when altered by a human being. This way, one can freely appropriate flowing water, can fish and hunt in the sea or in the air, and can also, as we shall see now in our focus, use the seashore as base for the uses connected to the sea. On this matter, Martian states that the seacoast is communis omnium, as I said, per hoc, which means that the seashore are meant to be functional to the sea, and so their nature common to all is thought to be instrumental to the exploitation of the sea. So the legal regime of the seashore is totally sea-oriented and obeys to the rules that emerge in this example. Since it is a res communis omnium, a Roman John Doe cannot appropriate the whole litus, also for practical reasons, of course, but can use it to put a casa, which is a fishing hut, you can see that there, functional to his fishing activity. Martian and other jurists who put this case forward state that in this situation, both the manufact and the land below are in the ownership of the constructor. So an open contradiction to superficies solo cedit, which is the normal principles in Roman and civil law. However, if for some reason the building collapses, for example, because of a storm, the part of the seashore on which it was built becomes again communis omnium immediately. And if someone builds something else in the same exact point, the old owner has no remedy to build his hut up again exactly where it was. The limit of this use of res communis omnium is that one cannot hinder everyone else's equal prerogative on the seashore. And in addition, as you see, Roman jurists state that passing of time cannot give foundation to stable property rights, this is Papinian, and that what is offered by nature on the seashore, like precious stones or gems, can be freely appropriated. It is worth mentioning that Roman jurists are often very cautious in defining the ownership of the part of the beach below the construction. If Martian himself, and before him Neratius, talk openly of dominium, which is the very Roman kind of property reserved to Roman citizens and on land located in Italy, other jurists use more nuanced expressions, for example, eius esse, inherent to a legal order proper to all mankind, the ius gentium. So Romans built Roman law and the law of everyone else, ius gentium. Perhaps this could be due to the awareness that res communis omnium could be used and appropriated not only by Roman citizens, but by foreigners too, also far distant from Rome. So we are now in the condition, we are now in the condition to build a parallel. Outer space, like the sea, is navigable and crossable. There is a difference between outer space and celestial bodies, of course, it is evident. Celestial bodies could be considered as basis for human activities, for example, to launch spacecrafts. I cite a movie, I'm sorry, in the movie Ad Astra, I saw this very well because the main character travels from the Earth to the Moon and then from the Moon to Mars, so it's very evocative, I think. So can we use the relationship between sea and beach as a model to read the definition of open space and celestial bodies as res communis omnium and in the OST? In my opinion, the treaty offers some hints in this direction, and I would like to focus on this part of Articles 1 to 4 OST. So I will be very fast in this. Article 1, paragraph 2 tells us that outer space and so on shall be free for exploration and use, and there shall be free access to all areas of celestial bodies. Article 2 is the non-appropriation principle. I won't repeat that. Article 3 tells us that state parties shall carry on activities in the exploration and use of outer space, and so on. And Article 4, paragraph 2, we heard many things about paragraph 1 from Diego, tells us that the use of any equipment or facility necessary for peaceful, of course, exploration of the moon shall also not be prohibited, so it's allowed. In these articles, we find some principles we are already familiar with. Freedom of use and exploration, incapacity of ownership, possibility to build facilities on the surface of celestial bodies, the principle of free access to all areas, and the consequent limitation to exclusivity. Plus, the exclusion of use and occupation as ways of acquiring property shows that, just like it used to be in Roman law, possession and passing of time do not give rise to stable rights on celestial bodies. So the similarity between the regime, this regime and the Roman one is evident, but the relationship between the possibility to build facilities and the incapacity of appropriation of celestial bodies is of course a big problem. Roman jurists tend to recognize a more or less full form of ownership over the part of the res communis omnium which is appropriated, and this seems to be in a frontal opposition to the non-appropriation principle, of course, of the OST. However, beyond the lexical difference between the use allowed by the OST on celestial bodies and the ownership recognized by some Roman jurists on the seashore, the regime is in the end quite similar, also because it is not easy to distinguish the full property rights and possession rights when the possession is is on. So in both Roman and international law, however, the constructor of the facility can use the area until the building remains upright, just like in a game of musical chairs, in which when someone eventually leaves his chair, someone else can freely occupy it. This was also written in international law. So, some conclusions. These are, of course, only suggestions from the ancient notion of res communis omnium that seems to become cyclically a cornerstone of international law, Grotius and so on. I do not think, obviously, that our problems of today and of tomorrow can be solved by the reference to this ancient notion alone, but I believe that before declaring the death of res communis omnium principle in favor of a full private ownership regime in outer space, like some scholars suggest today, it could be worth trying to preserve the non-appropriation principle a little longer, perhaps also taking advantage of the Roman experience, as seen above. It is clear, however, that this mixed situation between communality and appropriation could also lead to litigation, and states can try to avoid it in advance by modifying the OST, or try to solve them after they emerge to create a rule, an option, a better option, of course, from the point of view of the Roman law scholar. In the field of seashore and sea, Roman jurists had identified remedies that could be used to resolve disputes arising between users of the res communis omnium, and to do the same with outer space today, though states would have to identify a jurisdictional body to turn to, a perspective apparently not on the agenda of states at the moment. Thank you very much.
So I think we a little bit run over the times, but we have anyway a little bit of time to make some questions if you have. Okay, yes, we heard at first all the question and then we answer. Okay, thank you.
Thank you so much for the presentations. I took so many notes and questions, but in the interest of time, I'll just select two questions, but just two remarks before that. First of all, with a name like that, Falcon, I mean, you mentioned, Martian jurists. How about with Falcon, you have your own space company, as a true space lawyer. Second thought, Professor Ramos, you mentioned in terms of harm, a new vision of harmful around harm, and I was thinking, could you perhaps elaborate, perhaps in a paper or so, if there could be any links with harmful interference? Because it's a totally new perspective, so probably there could be some points there. So my main two questions, first one to Professor De Maestri. I was wondering if you have any insights on the inner mechanisms of the negotiations behind the coming law. If you have any feedback or insights, because I was wondering about the position of equality of member states during the discussions behind those the text, and then I was thinking and why the reason why I'm asking is I was thinking of potential frictions, because if I'm making the parallel with competition law, whenever there's a case, a case law in terms of national implementation of competition, and then, for instance, that jurisdiction says something about a company like, with particularly with data companies like the GAFAM, and then at the commission, it's the opposite, the reversal, and then there's tensions. So would there be any parallels with space law? If you have any ideas on that. And then my second question to Professor Vecellio. Are you like the cyberspace Sun Tzu? And do you have Sun Tzu, The Art of War? Do you have any insights, lessons learned, or guidelines for like smart contracts and artificial intelligence mechanism on smart contracts? So thank you so much. Well, yeah, in general, but of course with an potential application to the space sector.
Do we have other questions? Yes.
Hello, I have a I have a sort of a practical conundrum, and I was wondering how Roman law would answer this. This is very important for people that are doing astrobiology in my university. So here's the conundrum. There's a rover on Mars at the moment that is collecting samples. There's hopefully it sort of stores them in a container, drops them on the surface of Mars. And there's a planned mission, hopefully, it's not funded yet, and there's possibility of abandoning that mission for a rover to come and collect them, put them on a rocket and launch them back to Earth. This is a sort of a US and European-led program or a mission. And the hope is that we'll finally have Mars sample return to labs on Earth. The problem is that the US is considering withdrawing funding, so that means abandoning the mission and with that abandoning the samples. And there is a fear that China will send a mission to Mars and collect those samples. And as it is practiced at the moment, China doesn't share samples. So my sort of conundrum is who owns those samples and when, until when, and what happens. Thank you.
I will start to answer. Will you start? Yes.
Yeah,
Do you want to start first?
So, well, I don't have the idea of how negotiations are going. Why? Well, because also Professor Marchisio, to who I was speaking yesterday, who was appointed as being expert in the preparation of the text of the law, he also told me, I don't have any idea, but maybe we can ask Marco Ferrazzani that is here to give us an advice on that. With reference to the possible frictions, well, obviously there are. Obviously, using Article 114 will leave apart some, if there are little states that are not agreeing because the majority is enough. Obviously, within European Union legislation, there are always leading states that will promote a legislation that will be more favorable to their enterprises or their interests. And obviously, there will be it will be interesting for European spacefaring states. Not all the states of the European Union are spacefaring. And then let me tell that the competition problem of the European Union, let me tell that it is a problem because effectively European Union space activities until now have been led by ESA, and we know that ESA has a system that is in principle contrary to the fair competition of European Union rules. So it will be a competition problem, but we can use, for example, the telecommunication experience. Within telecommunication field, the European Union has intervened many years ago in the 90s with the liberalization directives and so on. And there, if you have a look at the directives, that I'm speaking about directives, but nothing imposes the adoption of directives in the space law sector. Maybe a regulation will come up, but it will be a more problematic issue. But however, in the telecommunication sector, you have the possibility for the member states to issue authorization that are based on different elements, even if the basic ones are set by the directive, but they can differentiate their own national system. So it can happen also with reference to space activities, but what is asked is to justify that difference. So member states maybe will be, well, let me tell maybe, because we don't have it at the moment, but it will be not contrary to national laws and the competencies of the member states to have common rules for authorization, but the possibility for the member states to leave their own national authorization regimes, but justifying why they need further elements or characteristic features or whatever. So there will be a problem concerning competition, but it's not a problem that cannot be solved, in my opinion.
Okay, I will follow the order, so I leave you. Yes, of course.
Hello. Okay. European Union, yes, European Union proposal of the draft legislation. I don't have the draft. Nobody has it around. And I don't have very much insider information. Of course, there are meetings in Brussels, but I don't have insider information. But I know something, and I can tell you what I know. It's not very much, but I can tell you, and I can give you some comments. First of all, from what the Commission has indicated, and also the Commission, also member states working in the Commission have indicated, it will be 114 the legal basis, because 189 cannot be. Second point, the main idea that you mentioned, the speech of the Commission, is about sustainability and resilience, which induces the idea of strategic autonomy. And therefore, the idea, which I find very good, is that the European Union wants to show to be leader in the world about sustainability and resilience. And this can be done through adopting in Europe, in the common market 114, because it's a common market, some criteria or minimal standards or exactly normative standards so that all European actors or those who want to work in Europe have adopted this kind of minimum standards. Yesterday, I was mentioning about the European standardization, ECSS. We already have, ESA is already a set of standards. They're public, you can use them. All European industry uses it. The difference now may be that the draft legislation, and that's why it will be a regulation, not a directive, may use the standards and put them at the level of EU legislation, which will make them not voluntary, not done by a few engineers without lawyers. It will make them standards, whatever that means in terms of European legislation. I'm not saying it's mandatory. I'm saying whatever it may mean under European legislation and internal market. Not space standards, internal market standards, for reasons of the internal market, which would mean, as Elena said, not to create additional barriers. But when you choose the standards, are you adding a barrier or are you easing the market? And here I would like to have some WTO lawyer to answer me, because you may know that WTO addresses exactly that point in terms of having common trade rules and circulation. It's a matter also of competition law outside of the EU, you can imagine. So I'm already adding a few comments that make you think. Anyway, you only have 1 more month to wait. The draft will be proposed, they say in March. They wanted to issue in January already, but because of internal, so-called inter-service consultation within DG, DEFIS, and internal market and competition law, the early draft was to be reconsidered, and now it will be issued probably with some differences. We will see. But you know very well that the European Parliament is going soon to recess in the elections. So in reality, the Commission will leave it on the docket as the last heritage of their mandate, and then will be reconsidered as such when the new Parliament meets at the end of the year. And then we'll start the session. Because when a Commission or Parliament ends the term, everything is cancelled to zero except the legislation which is already on the docket of the Parliament. That's why the Commission wants to send it to the Parliament for consideration before the Parliament dissolves. So they will remain with the new Parliament. And that's what Breton wants to do. Again, it's not a secret. You can induce very well from the speech. So I've told you all I know.
Just a very brief reaction to this standardization thing. I guess one of the problems is exactly this, that we are going down the path of segmentation into standardization as well. I mean, standardization for a while has been something that they have tried to maintain as global as possible, though of course it was dominated by somebody. That is not a secret. But through this domination, more or less, let's say, states tended not to over-demand their companies to disregard those standards actively. what is going on today is that we are gradually descending into this abyss whereby the European Union does its own standard. We already have a lot of harmonized standards in a number of fields which are quasi-binding. It's a very long story, but in any case, I've published an article on this for the European Journal of Risk Regulation exactly on this matter. So, but it's a very long story. But in any case, the EU is doing this thing. China is starting to tell, hey, don't cooperate with the US agencies because otherwise, you know, you're going into troubles. The US is continuing with its own rhetoric that they are the only technically supreme power able to craft standards that everybody should follow. Extremely paternalistic, and it's very hard to stay in those let's say contexts. So we are going down a very dangerous path by standards, which are the only left arena for cooperation, are also becoming basically centralized, but regionally. And I think this is I think this is very dangerous, and I'm not sure these moves by the EU are going to, if you ask, for example, you know, are they going to improve the market or not? Well, of course, in general, standards are assumed to lower adaptation costs. The problem is for whom? One could take the European approach and say, okay, they're going to lower adaptation costs for EU companies, but vis-a-vis whom? Anyway, okay, it's a very long story. I should reply to the actual question.
Another piece of information just for you as a fact, the European Commission publicly has said the regulation will not touch state capability or state competence to issue licensing under national space law, but will introduce technical standards for reasonable internal market. By introducing standards which today are not mandatory, inevitably, and we studied that, increase the level of quality, that's good, but also the cost of programs. And we already are looking at that. So it will not be a barrier, but it will be an increase of costs and also taking leadership. So if you want to be leader in something, you have to pay for it. So that could be good news for European space industry, where they have a chance to increase the quality, become leader with somebody that pays, and it's all of us that pay because it's taxpayer money that will be asked by European industry saying to the Commission, you want us to comply with the standards? It costs more for public programs, and therefore upgrade of cost of public program paid by the state budgets and governments.
And these are the commercial aspects. Then the
real first public programs, but then also commercial users.
Yes, and the next step of problem is that in the defense sector, you can't even reason this way because the main problem is not what market is prioritized, but are we able to secure a space that works more, example, for more or less.
It's a matter of it's a matter of money, public finance.
In any case, these are very long course, but thanks, really, I guess it's also very interesting to me. I should reply to the actual question. It's too hard as a question. I mean, well, I mean, give me half a minute. I've also skipped my slides, so okay. No, I'm not trying to give an articulate answer because it's too hard, I guess, for anybody. I've published a lot on AI, smart contracts. The problem is there anything different for space that, you know, it's additional or diverse compared to space contracts or AI in the debates that we have down on Earth? So when it comes to smart contracts, I don't think there is. It's only conceptual in the sense that, of course, smart contracts come with blockchains, so you all have this debate around decentralized authority. And one thing is to debate about that when it comes to Earth authorities. Another thing is to debate about that when we already are in a space that is a bit beyond, let's say, in national jurisdictions in some sense. So it's mostly conceptual, the difference, but I'm not aware of technical differences. And even when it comes to states, one issue with that is that, of course, private actors in space tend to overreach compared to national capabilities in certain domains. And conceptually, blockchains might be the only way states are going to be able to trust their private actors and what they do very far. But okay, this is, I mean, this is mostly speculative, let's say. When it comes to AI, the situation is much more complex, and I'm not going to try to give an answer seriously. The aspects, just listing them, are, first of all, remote sensing. So AI applied to recognition of things that are from there to here, from here to there, from here to here through there, and all these combinations. This is one aspect, but I don't have the time to elaborate. Second aspect, smart collaborative robotics. And this is something I really love to explore in my scholarship. There is an aspect of not only robotics, but collaborative robotics. So one day robots and humans in space, which raises a number of legal challenges which are different from those you have on Earth, and smart collaborative robots. So this is really powered by AI, and this is very, very technical, very, very important. There is also a matter of non-evidential belief and narratives among states, so competing race-based activities through generative AI. So of course, the generation of claims and evidence that are false or misleading or both or non-evidential, and the spreading of this misinformation through generative AI, particularly with regards to space. And then lastly, I will end with this, the problem of artificial intelligence conceptually compared to what is intelligence. Now, this is extremely speculative, but of course, one of the frontiers of space activity is to find whether we are alone in the universe and all these kind of things. Now, artificial intelligence, one of the problems in defining it is that we don't really know what intelligence is. So probably if we find somebody else that we might agree is intelligent or more intelligent than us, which is more probable because we humans are very, very not smart by many means. Well, probably that would also be helped by our debates about artificial intelligence, because this is preparing the ground to understanding more broadly what intelligence means in the universe. It can take many forms, and this is really interesting, I guess, from a philosophical perspective.
Just very briefly.
Yeah.
Okay.
So,
Thank you very much.
Not my briefly, by the way.
no, mine. So how would Romans solve the problem, the case? So short version of the answer, they wouldn't, they're dead. That's a methodological point, because one thing is to use their solved cases to solve ours or to reason. One thing is to put on new cases and to solve them as Roman jurists. But if we want to play this, so the first thing is that maybe if Americans want to keep the samples, it's better not to abandon the mission. But if they abandon the mission and they have the animus de reliquendi towards the samples, so they become a res nullius, a res derelicta, animo de reliquendi, and then the Chinese can acquire it for sure. If they put these samples in a facility on Mars, which is what I said, I would say it's inside the ownership of the US. I see no, but I know it's not an actual legal status. It's what I said. I don't want to polemize with you. I'm sorry.
Since ESA is supposed to go and get them, we already have the mission planned, and we have an agreement ESA-NASA to do that.
Okay.
The samples are now on the soil of Mars. They are not in a facility, and they have not changed the legal status. Either they're on the soil or extracted. The status has not changed.
Are they?
They're not owned by anyone.
Sorry, I didn't know this was an actual case, but I mean,
it's a real case.
Okay.
They're on Mars right now, and ESA is supposed to go there in 28 and pick up the samples, and together with NASA, bring them back into US territory. We have an agreement written on that.
Okay.
The point is that US Congress is changing the budget appropriation for that mission. So technically we can do it, but politically it's not confirmed yet that we will do it.
Okay.
So this is the status.
No,
This being said, I really don't believe that the Americans will just go into a derelicta situation and say, okay, go and get it.
I don't believe it either. I wanted just to solve the case, which was abstract because it was a Roman law case. So obviously, if you have an actual case with a court and so on, I won't question it. Yeah, it's a Roman name.
Good afternoon to all the survivors of the day. It's not 2:30 in the afternoon, but 1 hour more. In consideration of the different time for the speaker of this session, under suggestion of our convener, I will ask Purvi Pokarial and Deepa Dubey. Sorry if I badly pronounced it. I will ask if they are ready. We can give them the floor. So just to let them live a normal day, quite normal day. No, maybe not. So second call for web.
There's a message that sent.
Okay. So I will give you the floor. Please just, since I didn't know all of you, please take the first 20 seconds to say something about yourself. Thank you. So may I suggest while we are starting the presentation to say something, 2 words about yourself? So just to spare time. Thank you.
All right, I guess I'll start. My name is Marian Naevsky. I am a lecturer at the Open University. I'll just use this 2 seconds to say thank you very much for the invitation. Thank you very much for the wonderful 2 days.
Thank you. It was my fault, please.
I'm Mario Amoroso. I'm a PhD candidate at the University of Trento, and I'm also currently collaborating with Professor Nesi as an assistant to the International Law Commission. I hold an LLM degree in Public International Law at the Graduate Institute and a master degree in law at the University of Naples. And thank you for hosting us.
Hello. Am I
We can
audible,
hear
ma'am?
you. You can
Okay.
hear. Okay.
A very good afternoon, esteemed panelists. This is Deepa Dubey. I'm a lecturer at National Forensic Sciences University, Gandhinagar, India. And thank you so much for arranging this online platform for me. And I'm extremely honored to present a critical analysis titled India's Strategic Roadmap in International Space Law before you all. And if you go to the second slide of it, you'll be able to see that this is the part where I belong. So this is a Gujarat, and our university have 8 campuses. Without further ado, I would straight away take you to the main part of my presentation. So space law is the field at the intersection of law and science, and the allure of space and the greater unknown has ignited the widespread interest, as we have been talking from for last 2 days, and that interest has expanded into various domains. And because of this interest, there has been a lot of commercial ventures, and there has been a lot of talk about the liabilities, research, and sovereign right that are going to arise in that particular field. So the space industry has witnessed groundbreaking innovation in our last 7 decades, and right now it's worth exceeding over 500 billion. And with its main players as US and China, India has also made significant stride over past 4 or 5 decades. And in last 2 decades, especially with the launch of GSAT 11, GSAT 7A, Chandrayaan, Mangalyaan, which is one of the most cost-effective programs ever done globally, it recently came up with a policy, which is Indian Space Policy 2023. That policy here is envisioning to leverage advanced space technology for the various applications. And this particular technology here is there for the exploration, scientific exploration and communication. Now, if I'm talking about India, as my title suggests, that I'm trying to map it with the international instrument, so I have to talk about the genesis of international space law. That again is being traced back to 1960s and 70s. That pivotal time period gave rise to what right now we recognize as an international law. There are the international law here is a complex legal framework that is governing the activities of outer space, and there are n number of treaties, and these treaties and agreements are there as a customary rule at a times, and they are in a form of convention between 2 or multiple countries. the primary goal of this particular legal framework was to ensure the exploration, exploitation, and preservation of outer space, protecting it from the harm caused by the human activities that we are doing. Now, the presentation here is to explore the global space governance system at length, and it would further analyze the adaptation of international space law to domestic context, and it was going to set the discourse or discuss the opportunities for India to navigate its own path in this ever expanding field of space law. Now, international laws framework, when we talk about at the center of it is a United Nations Committee on the Peaceful Use of Outer Space, which is one of the key organizations, one of the key pillars of UN. This particular organization is responsible for the framework and for the regulation of space. And it has again enacted a number of treaties and convention, including Outer Space Treaty, Rescue Agreement, Liability Convention 1972, Moon Agreement 1979, Registration Convention, and very recently they have there is an introduction of space sustainability rating, which in my opinion is one of the very great initiative in reference with the environment. And on the similar lines, there was one guideline which was issued, Space Debris Mitigation Guideline 2007. If I am to summarize all of it because of the time constraint, I would say that there are majorly 7 to 8 principles of space governance. One of the a lot of them have been talked about in past 2 days. So I'll just give a brief. Peaceful use of outer space, freedom of exploration and use, international cooperation, liability for damage, registration of space object registration act, non-appropriation of outer space, peaceful settlement of dispute, and these principles have impacted globally into the facilitation of global cooperation, enabling the scientific exploration, promoting commercial and commercialization and innovation, which have evidently addressed the environmental concerns that are there. Now, if I am to say that they are the guidelines, but these guidelines also have a flaw. For example, when we talk about the Outer Space Treaty, this Outer Space Treaty is a very complex and ambiguous document that is there at a times. It is a very good cornerstone of international space law, but it have its own shortcomings. The terms, the general principles are so wide that each and every nation state can interpret it in its own methods, which may become a legal implication later on. Further, there's a limited enforcement mechanism within this framework because international law is not very much enforceable at a times, which is very evident in the current situation. So, like, for example, the Moon Agreement is there. Moon Agreement aims to regulate the exploration of Moon and other celestial bodies. The main stakeholders right now, which are playing a lot of role in outer space, US, China, they are not party to, they have not ratified this particular agreement. When we talk about the enforcement measures, there is also a liability convention which imposes liability, but the liability that is being enforced is not, it is not enforced through sanctioning, but there are diplomatic negotiation and arbitration that goes, and which makes the entire process a bit ineffective at times. One of the major concern is unequal representation of nation states. The nation state which started in 1950s, 1960s or so on are playing a vital role, whereas the underdeveloped countries neither have resources nor have seat at table to be involved in this particular framework. Now, if we see the India's space framework, we'll find that India have adopted all of these principles in its framework, but again, the enforcement is a big concern when it comes to India. So India has proactively developed a robust legal system for its space activities, and it have a number of policies, few legislative acts, and there are a number of institutions that are put into the place For example, there is a ISRO, Indian Space Research Organization, which is one of the pioneer organizations in the world when it comes to the space exploration or outer space use. Then the recent two organizations which are playing very pivotal role are InSpace and NLSI. So without taking a lot of time here, without telling a lot of details of the policy or the framework that is already in existence, I will take you to the problem that is in existence with one specific policy that is right now governing the national framework of India's space policy. That policy is New Indian Space Policy, New Indian Space Policy 2023. Now, New Indian Space Policy 2023, which is placed here, is a strategic roadmap for countries' space activity as being propagated by India's Space Research Organization. Now, this particular policy outlines India's goals, strategies for advancing its space capabilities for national development, security, and global cooperation. Now, this particular policy was last year approved by the Cabinet Committee on Security chaired by Honorable Prime Minister Narendra Modi. Now, when this policy is being approved, it became a beacon of guideline for the India's space endeavor. And this particular policy realized one thing, translated one law or one proposed law into in reality, which was proposed back in 2022 in the form of policy again, where India opened itself to a private stakeholders in reference with the space activity. Now, there was an opening, but there wasn't a proper regulation. So now, with the help of this particular policy, we set up two organizations. One is New Space India Limited, NLSI, which is again it is a government-owned company, which is there to which aims to provide launch services, space-based application, build satellite system in partnership with the private sector. The other expectation from this particular organization is that it is going to provide opportunities for the private sector to participate in the space activities and leverage their capabilities to support India's space program. Now, the other part of this particular policy is to establish the InSpace, which is another organization. This organization is going to work as a regulatory framework to free the burden of ISRO. It is going to become a bridge between the ISRO, which is a government organization which have a primary responsibility of space sector in India, and between the private stakeholders. So InSpace is going to be responsible for supervising the private sector activities. It is going to provide authorization to satellite launches, building launch vehicle. It is going to be developing the space-based application and other. It is going to ensure that the private stakeholders are in compliance with the international law, and they are also in compliance with the national laws also. So this particular policy is kind of opening the space industry in India for the private sectors. That is the major idea behind this particular policy that is there. And it also recognizes that there has to be international cooperation when it comes to the addressing of global challenges. And it also recognizes that outer space is a humankind's heritage. It is inheritance of humankind. So there has to be a cooperation in addressing the challenges that are coming up in the outer space. Along with that, the major stake here is that it recognizes the India's stand regarding the commercial extraction by the help of commercialization and by the introduction of new stakeholder, which is a private stakeholder, which was not allowed before 2022 and which got approved in 2022, but the mass of new stakeholder got introduced in 2023 with the help of this particular policy. Now, although I have been talking about the pros of this particular policy, but the problem here is, or the problem here is similar what is happening in the international space framework. That is, in the national framework, these are the important documents here are, except the ISRO's act, important documents are only the policies. Now, when it is policy, it is not a legislation, the enforcement becomes a problem. And whatever is written, if something goes wrong, there will be a problem of regulating that particular activity if it is not in part of a codification. So that's one important problem with this particular policy. The another important problem with this particular framework is that it does not, it does provide a gap, it does bridge a gap, sorry, between the technology and the research and the framework, regulatory framework, but there can be more elaborate document that can provide that. Another major concern is that this particular policy opens up or promote that there should be incorporation of or there should be promotion of startups, or they should be introduced into the space industry, but it fails to mandate the compulsory insurance. And if that is there, then the private sector, or at least the smaller companies, startups, will not be very much open to this particular idea. So this India can adopt these things from the looking at the best practices that are going on in world. One of the good example is when it comes to the insurance mandate, US policy is very not very exhaustive, but at least it mentions that. So that can be there. Now, if this policy is to realize into a legislation, and if we go into the capitalization of India's space prowess, then it needs to foster a public-private relationship more by translating into a legislation. By embracing these imperatives, now India can become and can become a global leader in the space law and technology. India is also into the space where it is looking towards development of human space flight, Gangayaan. So it becomes very important to provide certain insurance mandate, in my opinion, here when we are introducing the rain cubs or CuteSat missions within this particular sphere. So that would be it from my side. And I believe that India's strategic roadmap in international space exemplifies its commitment, and it is going, in future, it is going to transform this into something that is better for the space fraternity out there, space law fraternity out there. Thank you. Thank you for your attention.
Thank you. Thank you so much for your comprehensive explanation and interesting insights. Now we go on with myself. Sorry, I didn't say anything about myself before. I am an outsider, and there is this is the reason why I'm thankful to the organizer here, because I'm a researcher in private law instead, and now I'm trying to get closer to space also, not only to space law, to space as an object of research, since I am a part of the national PhD in space science and technology. So I'm what I want to do is how to understand how to manage space-related risks as far as private entities are involved mainly. If we want, as our countries, governors, and so on seem to want, innovation and to some extent also incentives to space economy and national space economy applications, we have, in my opinion, to ask ourselves what the law, also internal law in many cases, can do in order to achieve innovation and to give the right incentives to private entities and to private activities. While this is the main point for me, at the same time protecting collective and individual interests and rights. This is a point that maybe could add something to the framework that is already clear. I can benefit from previous contributions, so I'm very happy about that. I would try to say some sketches, only that in a few time, about risk management and liability mainly. And I will use the example of information and data and some new technologies such as automation, artificial intelligence, as examples to show how prevention of risks and compensations, so remedies for harm, as was just suggested by Eva previously, fixed at national or supranational level in some context can be eventually differently characterized in space applications. So we have to think about safety and security regulations, mitigation measures, at the same time, so also as entwined with compensation systems and tort law above all. Space activities can be understood as present and future of human and terrestrial culture. And space activities can be conducted and used in very different ways. We are, in my opinion, not aware now of what space activities can be considered also in the near future. But only some of these activities can contribute to preserve and save human and terrestrial life and ecosystem. Earth observation technologies, for instance, are helping humankind, but at the same time, several applications of space economy, scientific and not scientific, produce enormous number of debris and so also risk for activities and people, which create concerns for possible impact with Earth or with other celestial bodies or objects, etc. So the complex legal and regulatory landscape surrounding these technologies and applications should aim at fixing rights and managing risks at the same time. Now we have, as it was highlighted very, very brilliantly this morning, new players also in the field of space. And probably between public and private law, we can see, imagine, and find new categories in the future. Can put new actors or new intersections also among fields. We can even imagine some new solution in the future. I suppose also new disciplines maybe in law itself. Maybe, but in the meanwhile, we have to try to reason with the tools we have already available. So new legislation is an important issue. as for the European Space Act or national space legislation and so on. And we have to reach it in the best way. We have to try to correct also the inconsistencies of existing law when paying enough attention to the just issues. But we have also to read and reread and interpret existing special laws and regulations in light of the special applications. I mean that balances, fairness in attributing, for instance, duties and obligations among actors could be affected by space environment considerations. So there are, in my opinion, some new considerations to be done also in the domain of, for instance, liability for damages caused by special applications. It's well known that states under the Outer Space Treaty are assumed to bear international responsibility for national activities in outer space, even when carried out by non-governmental entities like commercial companies. Now, it has been said already that states must grant authorization for activities and they set control over these activities. And there is some kind of discussion about the real broadness of this kind of duties and obligation. But the liability that follows seems to be absolute, at least in light of the liability treaty. So liability, strict liability and for all damages when damages are on Earth, and for special damages we have a fault-based liability. For me, as a private lawyer, this is it's not enough. It's not enough to explain how to manage this kind of situations and the causation. First of all, we have a problem. We may have a problem of forum shopping. I mean, launching shopping. I don't know how to call it because commercial companies or private entities can try to choose under which national law to operate in the space on the basis of the kind of authorization of control that the different states can pose. And on the other side, national laws, national space acts normally should decide how to share, I don't know if it could be the right word, the responsibility among actors. Above all, we have the state as international liable actors, and then we have the several stakeholders, operators, private entities, which under national laws should bear responsibility and liability for damages, let's suppose. So we don't have any international standard on which legal, on the applicable standards for gain authorization, for instance, or the minimum standard for safety or security requirements for the space activities to be conducted in space. So this is up to each state and national law to decide about that. Maybe it could be a problem of competition, as I suppose was suggested by, it seems to me it was Professor Marchisio just before. Because if we have not a single state, but also the European Union that poses some standard for conducting space activities, if the standard is high, we can create a deterrent incentive. It's the contrary of innovation or of the run to space that we are trying to push in European Union. Nevertheless, without any standard, it's easy to have very different choices at national levels, and with an insight also to geopolitical movements and competition rules, we can imagine that the competition is not in the interest of the collectivity, but only maybe of the business and the business in some countries. So this is a global risk. But out of that, we have a international liability up on the state, on the launching state, and then the different but connected liability or liabilities for individual and private entities. It's really important to understand which is the role of each of them for a couple of reasons. First of all, the state liability could be considered, in my opinion, a warranty for some kind of interest. It's in an international treaty. It was the age of Cold War, and so maybe we can understand that the protected interests were the humankind, the community of states, and only on a second level, the individual rights. It was a sort of warranty that the collective interest of all the states could be protected at a very high level. But there is, of course, there is not a basis for liability under national laws for that. We have to think also that not every national activity have the same level of importance, of interest achieved, the same goal in some sense. And they cannot be treated in the same way, mainly. We can think also in the previous contribution, space application are scientific exploration, communication, business, launching, transportation, tourism, Earth observation, and so trying to preserve sustainability and the biodiversity and so on. Very, very different kind of activities. So under national laws, the model of liability for each of these activities is regulated in different ways. In many cases, strict liability, for instance, product liability. In many other cases, we use a fault-based liability when we want to use tort law, so compensation for damages as a residual hypothesis when safety and security measures are not enough. But we have to think, this is I think the main point in what I want to say today, that if we think about the liability models that can be introduced by each national state or the European Union even, of course, we have to think the liability models as intertwined with the regulatory framework of each activity. We have to move, in my opinion, from the kind of risks and the kind of harms that we are trying to prevent. And on the basis of that, try to put together the existing laws and regulation and try to interpret them also in light of the peculiarities of the space environment. Just think about the fact that also the assessment of fault in space can be different. It's not only a matter of time delay, time delay in communication. It's also biological diversities in space. Think about personal injuries, for instance, in space. So we have to understand how to apply, of course, the single elements of a liability rule, and we have to think about how to assess the damages. These are two dimensions that can and should condition also the insurance availability. And insurance is one element that in national special acts are very often present. But if insurance is not in reality available, it's a great problem also to meet the requirements from law. So, and concluding, any national space law should be combined with existing regulatory frameworks, governing generally the activities that from now can be undertaken also in space. A good example could be the use of data, for instance, as with the large gathering of data gathered in space with satellites, with Earth observation and so on. This is a good point. Regulation, circulation, and processing of data. The use of artificial intelligence or autonomous tools and technologies in space. How to apply or to adapt in some extent existing regulation, and as existing, I think also at the upcoming regulation, AI Act and so on, to specific goals or contexts. Think only about the necessity to correctly understand the sense of autonomous tools, autonomous machine, or the problem of a human oversight on artificial intelligence system that maybe in space or in the context can be considered of high-level risk under the European regulation. So I suppose that we have to analyze pros and cons of different solutions, but I think that it could be a good idea to start from a risk-based basis, moving from application, concrete applications of space economy activities in the variety of activities. It's possible to identify specific risks to take into consideration, specific problems and legal issues in the application of general existing law, and thus try to imagine solutions suitable to manage risks specific for space, but while pursuing the goals of regulators that are already posed in general regulation. So this is my little insight in space private law. Thank you. And I give the floor to Professor Marian Ajewski. Is correct? Oh, no.
Hello, so my name is Marian Iaskin, and as I said, I'm a lecturer at the Open University. Thank you for the promotion. I'll tell my promotion committee. So what I wanted to talk about today was sort of, as the name on the tin says, analogies for space law, but mostly the idea that space law is bigger than we normally give credit for. And being sort of on the final panel of the conference, luckily a lot more people made the same point. So that luckily shortens my presentation. Um, um, so I'll hopefully stay within the 15 to 20 minutes allotted. So one of the things that kind of prompted me to do to put in the abstract and to sort of structure this talk was the kind of narrow notion that space law is found within in the four corners of the Outer Space Treaty and its four progeny. So luckily, as we've seen in this conference, that's definitely not the case. But as we can see, it's sort of from this tweet from Commander Hedefield, so a former astronaut, he tweeted like not even a month ago when thinking about who should own the moon. Interesting that all existing space law fits into this little booklet. The booklet is quite nice. You can download it for free. It's University of Mississippi sort of a publication, and it has the five treaties, UN resolutions, and finishes with the Artemis Accords, of course. So the I think what probably the consensus of this sort of conference is, and all what has been pointed out by a lot of people in both the presentation and in the audience, space law is quite much bigger, right? Article 1, Article 3, or the Outer Space Treaty specifically call towards international law, that space activities need to be conducted in accordance with international law, and that international law is that international law governs outer space. So essentially, what's in the booklet plus the entire international law section of pick a library, and you have space law. And as was also pointed out at this conference, it's not only that, it's also private law, it's also national law, and of course, there's also EU law, hopefully coming soon. So my general point was that sort of because space law can be so broad, it's a branch of international law, it's kind of not helpful to think that that sort of the space law is this narrow, vague, or sort of silent five treaties, and that it doesn't have much to say about what's happening and how do we regulate space activities, simply because international law has grown so much in both depth and breadth since the Outer Space Treaty was first drafted in 1966 and opened for signatories, and after it came into certainly after it came into force. So, what does that mean in practice? Well, as a lot pointed out at this conference, the general doctrines of international law apply to outer space, so that means both the sources of law doctrines, the sort of the basis of it, the norm recognition, use Cogans, of course, and if you think which use Cogans, we already had sort of a talk about the application of the rules of war in space at this conference, so that's the easy one. The more we go into space and the more we turn from astronauts to employees, things like the prohibition of slavery and modern forms of slavery, as the use Cogans, also comes applicable. Questions of erga omnes, because as we also heard yesterday, outer space is thought of as a commons or a common heritage of humankind. But the basics of what that means means that it's an area beyond national jurisdiction, which means that there are ergo omnes interests and ergo omnes rights that are protected within international law. And specialized regimes from international law also apply to space, as we saw again in this conference. Human rights, for instance, wherever there are human beings, there is law. I will not cite the Roman maxim because I'm in Rome and I'll get it wrong. But humanitarian law, already spoken at this conference, environmental law, which I will use partly as an example to sort of to illustrate this, but everything else, as we heard yesterday, for instance, there's a lot more regulation happening of space law in the insurance sector than I've certainly knew about. So I wish I made this speech at the beginning of the conference rather than at the end. So let's use space as an environment as sort of an example. And I chose space as an environment specifically because it's one of the harder examples, because environmental law is also sort of norm poor in the sense that the way that we do international environmental law is through process rather than hard norms. But that doesn't mean that there aren't any. So for instance, the Environmental Modification Convention, or the Convention on the Prohibition of Environmental Modification in Times of War, considers outer space as an environment. It's specifically stated there as part of sort of the areas of the Earth that it protects, including outer space. So in one sense, we already kind of treat outer space as an environment, at least in one convention specifically. But the International Telecommunications Union, for instance, considers electromagnetic frequencies and orbits to be limited natural resources. And you can see why sort of orbits are limited natural resources. If you see sort of this on your right, the specific orbit proposed for the Lunar Gateway, which is designed so that it keeps maximum contact with both Earth and the proposed lunar base on the South Pole. Everything proposed. But the general idea is that once the Lunar Gateway gets into this orbit, it kind of excludes everybody else from getting into a similar or same orbit, or even an inverse orbit where you have a base on the North Pole because of security concerns and because of possibilities of collision, et cetera, et cetera. So they are sort of limited natural resources. And when it comes to ideas of limited natural resources, how do we treat the environment? There are certain principles in domestic law and certainly in international law which try to do both things, try to balance exploitability of natural resources, exploitability of the natural environment, and preservation. We already had a sort of a presentation today on the sustainable development of space, which comes from the Sustainable Development Principles, and that exactly was specifically stated, which is that we have a duty to preserve, to use space for development, or space as an environment for development, but also to preserve it for future generations. Right. So there's these types of norms are percolating both through international law and entering into space law, and they're becoming relevant. So as an area beyond national jurisdiction, right? Call it a commons, call it a common heritage of humankind. There are specific norms on resource use. Yesterday was pointed out that, and I agree with this, that the law of the sea, both if you treat it as a commons, we have analogies with the high seas, or if we treat it as a common heritage of humankind, we have analogies with the seabed, in which we can use the ways that we manage the seabed or the way that we manage the high seas. It's going to be in the next slide. Specifically, sort of as an area in which we can take inspiration for how to regulate these activities in space. There are rules of transboundary pollution. Now, there are no boundaries in outer space in terms of national jurisdictions, but in the pulp mills case, in the ICJ specifically, it said that when states there's an indication that their economic activities might lead to transboundary pollution or pollution to areas beyond national jurisdiction, i.e. commons, i.e. a common heritage of humankind, then they are required to conduct environmental impact assessments. Now, there's things that we can use from this in terms of the responsibilities of national licensing agencies when they look at authorizing new launches or new satellites or new missions in space. So particularly, it is becoming important to ask how a new satellite launch will affect the already crowded space environments, close Earth orbits, and specifically certain states, although very minutely, are moving in that direction. So, for instance, the U.S. issued its first fine for a network that a satellite operator that didn't perform a proper disposal of its satellite into a graveyard orbit of its GSO, satellite. So as we can see, these are there are some hard norms that are quite specifically applicable to nation states, and we've already seen that nation states need to incorporate this into their national laws. As I said, this would have been much more interesting at the beginning of the conference than at the end. Space as an environment can also be can also have or it can use examples not just in terms of norms, of hard norms, but also as terms of process. By process, I mean that there has been, and as you can see from the top right on the screen, as you can see, this is a track of multinational environmental conventions. And as you can see, following the slowdown of multinational conventions, the cadence of signing up to new international conventions globally. So that also applies for the environmental part. Somewhere around 2003, the world just kind of slowed down or stopped making multinational conventions. And there's also and the only one that has bucked that trend, to put it mildly, is maritime law. And the reason for that is because there are certain diplomatic, let's call it, or realpolitik forces that make it so that small island states or developing states have disproportionate power to regulate areas of the sea. As you can see, the dark blue is the high seas, so that's the area beyond national jurisdiction. But the white, or not the white, the light blue areas are actually economic zones, exclusive economic zones. And as you can see, small island states have comparatively large economic zones compared to their area, which means that they also have a lot of pull or power, because those light blue areas are also where a lot of fishing happens, because fish follow currents, which follow coastlines. So they have a lot of the natural resources that they manage. So they have extra power because the global north states want to use that. So there is both a coalition building within the global south states, or the small island states, the developing states, who want to regulate the fishing, overfishing, biological protection of biological and genetic resources, et cetera, et cetera. So they kind of made the bigger states come to the table and come to a compromise, which would not have benefited them because the sort of the similar logic to space as a commons applies to the high seas as a commons. So the first mover advantage, the states that have the possibility, or the companies that have the possibility to have these expensive big ships that can do they can fish in both high seas or in other economic zones. They will be the ones who gather most of the spoils. But because the UNCLOS, the United Nations Convention on the Law of the Sea, gave smaller states, archipelagic states, a power to regulate their economic zones, and because the economic zones are so large, this kind of sort of gives them different power. Something like this might, or at least there's an interest from also the global south of these states, might also apply to outer space. Small island states and states in the global south are very much interested in having communications, access to communication and communication satellites from space, because for them, they cannot simply just put a cable for communications or for internet or etc. And having reliable, fast internet or communications from space is kind of important to them. So they really would not like all of the orbits, or they really would not like all of the satellites to be taken over by sort of these powerful spacefaring nations. The coalition is building also because of climate change, and we have seen that they are quite comfortable in using lawfare, so asking for United Nations General Assembly resolutions, asking for advisory opinions from the ICJ, asking for advisory opinions from the International Tribunal on the Law of the Sea, to build norms on climate change and to build hard norms on climate change, because they have seen that the process-led climate change efforts and process-led environmental efforts, going for process rather than norms, hasn't helped them. And I think that once they build this coalition there, that coalition will stick and will move to other things that are of importance to them. Now, this is sort of a call for a wider use of analogies in space law and a wider use of sort of seeing what's happening in other branches of international law that we can nick and put in, or adapt and put in. But of course, there are limitations, right? Big question is whether we have the same purposes or impulses for, let's say, environmental protection on Earth as it is in space, right? There's yesterday somebody pointed out when talking about human rights, the very anthropocentric view of rights, human rights to the environment, as the way that we sort of think about human rights, or the right to the environment is the clean environment for human beings. But the Inter-American Court of Human Rights, for instance, when it was asked to give an advisory opinion on the human right to the environment, also specifically said that no, we protect nature for its own sake. So we don't just have human rights to the environment, we also have the environment also has specific rights because it should be protected for its own sake, regardless of whether it produces clean air for us or clean water or et cetera, et cetera. So what I'm trying to say is, would we be concerned about outer space environment if there weren't these cute dolphins or pandas or et cetera, wildlife in space, right? Does it matter whether we find life on Mars or whether we find life in deep space in the solar system? To think about environmental protection and possible biological protection of these future ecosystems. So the big question is the limitations of this limitation is, do they share the same purpose, right? Do we have the same rationale for environmental protection? This is important because, as I said, the environmental protection is about creating a balance between exploitability and conservation. And if we don't kind of share the similar rationale for protection, it will all topple on exploitation, right? And the general idea is we have screwed up a lot in the past 50, 60, 70 years regarding how we steward the environment on Earth. So let's try not to screw up when it happens to the environment of space. We've kind of there a little bit with when it comes to orbits and when it comes to space junk. And sort of the law of the sea has, and I talk more broader than just the law of the sea under the UN Convention of the Law of the Sea. Excellent. The law of the sea, I think specifically here of the London Convention on marine dumping, the London Protocol that strengthens that dumping, the various regulation coming from the International Maritime Organization on the amount of sulfurs in the fuels of shipping, et cetera, et cetera. Things that might be important for the space, for regulating space, because we know that rockets also cause possible damage to the ozone layer. If we continue on with the cadence of launching and just exploding, there's also impacts on the atmosphere, and it's not just so our atmosphere, but also, as I said, the space environment. So these are important things to consider. These are just sort of quite broad paintbrushes, hoping for questions if you're not exhausted after 2 days. Thank you very much, and the floor is, I think, yours.
Thank you so much. The next presentation is the one by Ivan Fino. Oh, the door is yours.
Good evening. First of all, I would like to thank again Sirio Zolea for the opportunity to be part of such a prestigious event. And the subject of accession is part of the studies I've carried out on the implementation of a legal regime based on the possibility of recognizing property rights over celestial bodies. In this research, I particularly point out that the principle of accession justifies the implementation of a legal regime that provides property rights on celestial bodies, and at the same time, I explain why the legal principle of accession will be fundamental if that hypothetical legal regime is actually implemented on celestial bodies. Moreover, one of the aims of this study is to avoid conflicts that in the future might arise over celestial bodies between different states and private companies. A far from idle question may be asked, supposing one day large and permanent settlements were created on celestial bodies, and in that case, the need may arise to accept accession in the space domain, when there is no different agreement between the celestial body plot owner and the entity building a structure on the same plot. So, but what does accession really mean? The term accession refers to the fact that whatever is built on someone else's land belongs to the owner of that land. So, accession operates only when the object is built by a person other than the owner of the land. In other words, the owner of the land acquires ownership of anything attached to the land. Therefore, as a consequence of incorporation, the owner of the said land also becomes the owner of the attached structure. So, in land law, the foundation of the modern law of accession is the famous Roman law Superficies solo cedit. And many of the current legal systems, not only of Roman origin, provide specific rules for accession. Also, British law, thanks to Bracton, accepts the superficies solo cedit principle under the so-called tenant fixtures. In South Africa, when a movable asset becomes part of land ownership, we have immedificatio. US law also provides for a broader concept of accession, and more precisely, a chattel is considered a fixture, then it could be considered an integral part of the real property when it is affixed to the ground or brings an improvement to the land. Generally, I mean, every legal system assigns a particular value to the land for what is located below or above it. As I said before, a far from idle question will be asked if one day large settlements were created on celestial bodies, and the need may arise to accept accession when there is no different agreement between the landowner and the entity that builds on everything, a structure or a building on the same area of the celestial body. Okay. Different reasons could underlie the accession in outer space and might be the same as terrestrial accession. Generally, there are two different criteria for property accession, and the first one considers the possible damage caused by the removal of the structure, and the second regards reduced utility. Regarding the first criteria, the attachment to the ground justifies the accession, and since its removal could cause damage to the structure or even to the land. Suppose a research station is fixed on Mars for stability or for reaching underground resources. Any attempt to remove the station could cause damage to the Martian plot and to the station itself. In the second case, accession applies to the essential part of the structure without which the infrastructure would be incomplete, even if it could be removed. For example, in this case, consider a lunar base with the solar panels installed on it, and the solar panels obviously can technically be removed without causing any damage to them or to the lunar base. However, without these solar panels, the lunar base would be incomplete and non-functional as it relies on these solar panels for power. Therefore, the solar panels could be considered as having acceded to the lunar base and then in turn to the lunar plot. The principle of accession, which is normally accepted in civil and common law system, is completely at odds with the international legal regime of outer space. Why? The accession cannot therefore be applied to celestial bodies. The superficial solar shaded principle, as we said before, and the outer space treaty provisions are in fact in contrast with each other, specifically because of the non-appropriation principle stated by Article 2 of the Outer Space Treaty. Of course, the accession principle over celestial bodies can only be implemented, as I said at the beginning, when and if property rights over celestial bodies would be granted, whether by an international authority or otherwise. As I said, this study is part of a broader research I'm carrying out on the recognition of property rights over celestial bodies. So, under the current space law, and specifically because of Outer Space Treaty, the ownership of any base or additional elements will not change. Just take a look at the Article 8 of the Outer Space Treaty that says that jurisdiction and control over registered space object this article says that countries retain jurisdiction and control over registered space object. In addition, the last part of this article, of this provision, states that the ownership of the space object does not change. In other words, any object that is launched or created inside with, for example, in situ resource remains under the jurisdiction and control of the state. On top of that, the ownership of this launched object does not change in space. So what are the outcomes, the possible outcomes of this contrast? Therefore, there could be a multiple ownerships over the same area of the celestial body. Apart from the ground, the ownership of the base could be different from the ownership of the added components. So the main risks of this situation would be the fragmentation of ownership rights over the same area of a celestial body. In this sense, the implementation of the accession principle would regulate the hypothetical conflict that could arise between different owners when there is not a specific agreement amongst them. Generally, the possibility of multiple competing actors over the same plot could compromise the rational exploitation of the property. On the contrary, the implementation of the accession principle on celestial bodies would provide us with the same advantages of the accession on our planet. And we know that land is characterized by a sort of immutability, and the land remains the same regardless of any activities on its surface. So with the accession, by prioritizing the interest of the celestial body owner, the accession principle would protect the general interest, and there is no doubt, in fact, that the removal of other companies' structure, as is stated by the current space law, and in particular by Article 8 of the Outer Space Treaty, the hypothetical removal of other companies' structure would lead to a waste of energy and the loss of wealth. Thus, the concrete implementation of the accession on celestial bodies would have the advantage of safeguarding the efficient enjoyment of the property, proving to be economically rational. From a practical point of view, the accession would also favor the simplification of hypothetical real estate transactions regarding celestial bodies. From this perspective, the third party interested in purchasing a plot on a celestial body can rely on a kind of hypothetical land register, given that everything that is fixed on the celestial bodies would be included in the purchase price given to the accession principle. So as a result, there will be no danger of ignoring what is included in the land ownership, for example, bases, infrastructure, cabins, and buildings of any sort. Hence, the underlying principle of accession will only follows common sense, and particularly when the plot owner and the owner of the structure or of the buildings built on the plot, on the celestial body plot, have made any prior agreement. To sum up, the rule by which the owner of the celestial body plot acquires ownership of the materials incorporated ends up realizing the general interest from a dual perspective. One related to the safety of the real estate transactions, and the other being economically rational. Finally, this research also considers that in some cases the owner of a structure may remove it in specific case. At the same time, a regulation may address the need to protect the integrity of space bases and structure, preventing space settlement from being jeopardized. For example, suppose the first example, suppose a private company we call A builds a structure on the ground of a celestial body with materials from company B. For example, materials from space mining. In that case, company A must pay the value of the materials if the separation is not requested by the owner of the material themselves within 6 months, or the separation cannot be done without serious damage to the structure. And this rule is similar to Article 935 of the Italian Civil Code. In addition, rules are laid down to prevent accession. In the second example, rules are laid down to prevent accession from having an effect that benefits the landowner to the detriment of the third party that builds a construction with their own materials. In that case, the owner of the plot can either retain them or to have them removed by who made them. If the landowner prefers, for example, to retain them, he has to pay at his choice the value of the materials and the price of the labor of or the land's increased value. And it is similar to the same rule is stated by Article 936 of the Italian Civil Code and Article 555 of the French Civil Code. So my ongoing research focuses on how to ensure a balanced development of settlements over celestial bodies, taking into account some domestic legislations, as we just saw. So thank you for your attention.
Thank you for the presentation. Very interesting. You have a good imagination for the application, and for the respect of time, of course. So the floor is for Mario Pasquale Amoroso, please.
Thank you very much for the word. And as Professor Pedrazzi said yesterday, the only obstacle at this point between you and full liberty. It's quite of a burden for me now, but I will try to be brief. And first of all, I would like to thank the organizers for giving me the opportunity to participate in. Sorry, can I have the keyboard? Okay. Just one second. Thank you. So I was saying, I would like to begin by thanking the organizers for giving me the opportunity to participate in this conference, and also to all the speakers that have contributed during this conference to this very interesting debate. And there are a few speakers that have also touched upon some topics that are a starting point for this presentation and does allow me to go faster on some points. So when we think of space wars, our pop culture background immediately brings us to a more than famous 1980s franchise in which the idea of space conflict was still tied to the imagination of a filmmaker. However, Lucas movies represent, fortunately, I would say, a reality that is far removed from the current nature of activities the states are carrying out in outer space, even if it does, in a certain sense, foreshadow the intention of states to have control or to exercise sovereign prerogatives in a territory that just 17 years ago was not even discovered. And therefore, rapid technological developments have made it possible for human activities to take place in this new environment, for societies to share interests in the exploration and exploitation of this new environment, thus creating the conditions for conflict to arise. However, we also need to understand how the current reality of space warfare has not, of course, yet reached a level of intensity that, due to the technologies currently available, allows us to speak of space wars in the true sense. First of all, because the term wars nowadays usually used to refer to hostilities preceded by a formal declaration of war, or also to hostilities that are of such a large scale that create a state of war that is clear under international law. So when there is an intention clear of the parties to create a state of war, and this is not the case with military activities in outer space nowadays, because we have a situation in which what we are currently experiencing are just some isolated tests and some tensions related to the development of new space technologies or the positioning of new weapons in orbits at strategic locations. Similarly, it is also doubtful that any of these activities that have taken place in outer space so far has, to the date, then have led to the outbreak of an armed conflict as defined by Article 2 of the Geneva Conventions, so common Article 2. In fact, for an international armed conflict to exist, according to what is called the first shot theory that is reflected in the commentary to the Geneva Conventions, there must be hostilities between the armed forces of two or more states without any threshold of intensity. Yet, even in perspective, so when military activities will be carried out in outer space, we cannot talk about international conflicts in space in every case. So in every case, states recur to all the kind of weapons and technologies that have been developed so far. In fact, while the recurse to anti-satellite weapons, so kinetic weapons, would allow to affirm to affirm the existence of international armed conflict because they could be qualified as a use of force, so as a hostile activity. The same cannot be affirmed in relation to the recurse to other technologies such as electromagnetic weapons that cause little or no physical damage to space objects, even if we have to underline that there is a minority position that considers similar activities such as cyber attacks as hostile activities that would allow to surpass this threshold of intensity, but is a minoritarian view. However, what can be easily affirmed that will be object of my intervention is that military activities in outer space cause material damage to other space objects and moral damage to states when weapons temporarily or permanently deactivate the functions of these space objects, so mainly satellites. These activities could give rise to state responsibility under the special legal framework of outer space law, but also under other legal frameworks that I will briefly analyze in the end, such as environmental law and humanitarian law that, according to Article 3 of the Outer Space Treaty, are applicable in the outer space context. However, not all hostile activities in outer space cause damage in the legal sense, and therefore this is the purpose of my intervention. So to interpret the meaning of the term damage within, in this case, Article 7 of the Outer Space Treaty, that talks about a general regime of responsibility in outer space, in order to examine which military activities that are taking place, such as tests, and also will potentially take place in outer space, could give rise to state responsibility. So the starting point, and I will go fast on this because it's been touched upon today, is Article 4 of the Outer Space Treaty that is rather outdated and is not able, in a certain sense, to give concrete meaning to the purpose of the preamble, that is to consider, first of all, outer space as a common interest of the mankind, and also that affirms the principle of peaceful use of outer space, because it affirms only, in a certain sense, a full demilitarization of celestial bodies, while it only prohibits the placement of certain of weapons of mass destruction in the empty space between celestial bodies, thus excluding from its scope of application a lot of different technologies that have been discovered and also developed recently, such as anti-satellite weapons that I referred to before, but also explosive weapons such as ballistic missiles and intercontinental ballistic missiles that, for example, do not follow the Earth's orbit, while the only weapons that are covered by the Article 4 and prohibited by Article 4 are those that follow, for example, the Earth's orbit. Therefore, we need to look to another set of rules that in this case are Articles 6 and 7 of the Outer Space Treaty that establish a general regime of state responsibilities for activities in outer space. In fact, while Article 6 establishes only a general regime of responsibility for national activities that are in contrast with the provisions of the Outer Space Treaty, Article 7, it's more detailed. It's more detailed because it affirms a system of responsibility that revolves around the concept of damage that is central, and also attributes international responsibility for damage caused by space objects to the launching states and to the states that procures the launch that is included within the definition of launching states. Therefore, in order to understand what conduct determines responsibility of states for military activities, it is crucial to interpret this term damage, so the meaning of the term damage within Article 7. And in fact, damage is not in the law of state responsibility. So in the articles on law of state responsibility, a condition for international responsibility to arise. But the direct reference in Article 7 makes it a condition in case of damages to space object that we need to take into account in order to determine the material, so the objective element of state responsibility. Damage, as stated in the commentary to the RCWA, includes both material and moral damages. So in this case, damage to property and to pecuniary interest, and also individual pain and suffering and interference with private life. Similar wordings are also adopted in the 1972 Liability Convention, but its scope of application is more limited because it limits, for example, moral damage only to loss of life, bodily injury, and other injury to health, and material damage only to damage to property. Therefore, the next step is to examine the nature of the damage caused by the various space weapons that have been developed and then are already in orbit, and also the ones that could potentially be used in the future, to see whether state responsibility could concretely arise. So taken together with nuclear weapons that are already prohibited by relevant international instruments and also by Article 4, we can easily affirm that all the weapons that cause the material destruction of satellites and space objects can give rise to a material damage that would allow to affirm the existence of a state responsibility. This is the case, therefore, for anti-satellite weapons, that cause damage to property, in this case, so satellites registered by other states, but also explosive weapons such as I said before, ballistic missiles. However, this is not the only case because rapid technological development have led to the development of other new weapons such as direct energy weapons, for example, that include laser weapons that could, by directing a ray of light against a satellite, against a space object, cause this material destruction of a satellite. At the same time, the material destruction is also derived from the connected consequence of these material damage, so the production of space debris that's circulating following according to the Kessler effect that regulates the Earth's orbit, that circulate at high speed in the Earth orbit, causing potentially material damages to other space objects. However, the situation is not so straightforward in all cases. In all cases of space object that will be launched in outer space that can be qualified as space weapons, even if this term, as we also observed before, is we cannot understand fully to which kind of object is applicable, because states have developed a range of weapons that are designed to circumvent international obligations, such as particle beam weapons that simply hit the surface of space object with the aim of destroying international mechanisms. The same consequence is related, for example, to electromagnetic weapons. And therefore, in order to determine whether the damage caused by this object could be qualified as material damage, it could be useful to examine a soft law instrument, so the Tallinn Manual, that regulates similar activities. Is soft law instruments, but has acquired some relevant in the last years that could allow to affirm that some provision, some provision of the manual assume a more stringent are more stringent obligation than soft law obligations. Therefore, cyber attacks, in fact, not always cause the material destruction of the target, therefore can be compared to the recourse to electromagnetic weapons. And in the Tallinn Manual, it is affirmed that material damage, for example, occurs if the target state is obliged to replace the damaged components, meaning in cases in which there is a pecuniary damage, so like reflecting the position adopted in the RCWA. But in my opinion, this position, so this idea cannot be applied in the same sense also to space activities, first of all, because the recourse to electromagnetic weapons and system of interference in general sense causes of damage that could be considered a pecuniary damage, but the liability convention only covers damages to property within the definition of material damage. And that's the first thing to be considered. And the second thing to be considered is that a contextual interpretation of the Outer Space Treaty, also in light of the position of the General Assembly that Diego referred to today, cannot allow us to consider that all military activities in outer space are prohibited, and therefore those that are not specifically and evidently prohibited are actually allowed. So the process of militarization does not apply fully. States need to respect, in a certain sense, the obligation of the Outer Space Treaty, where the militarization is only applicable to weapons of mass destruction, and at the same time, the principle of freedom of use of outer space is paramount, and therefore is the element that states have to follow, so that inspires states in their activities in outer space. Similar consideration can be applied to moral damage, so it is also possible to analyze whether the use of system of interference can determine, for example, moral damage within the meaning of Article 7, because, for example, they interrupt some essential services, such as communication and navigation services, causing, of course, an interference with private life that is included in the definition of the RCWA, but at the same time is not included in the Liability Convention, where moral damage is only limited to loss of life, physical injury, and other health impairments.
all consequences that, of course, would rarely, in a certain sense, result for the deactivation of satellite systems. At the same time, if we look at the jurisprudence on the interpretation of this idea of moral damage, for example, the Lusitania and the MV Saiga case that are quite dated, but at the same time are some of the main example in this case, we can observe that compensation for moral damage is awarded in the case to impairment or to private life only in cases in which there is a conduct that is detrimental to individuals, in the sense of conduct that are cases of deprivation of liberty, ill treatment, and causing mental suffering, but not in the case of conduct affecting the normal functioning of community life, which will be affected by the interruption of satellite functions. Therefore, in order to obtain a complete picture, this is the last part of my intervention, it might be interesting also to examine in other international frameworks, in particular environmental law, to see whether we could go further. In fact, military activities in outer space alter the orbits that can be legally qualified as an environment, both as natural resource and as center of natural processes, through the proliferation of space debris that are caused by the collisions and explosions also to military activities. So these orbits, in a certain sense, can be considered as an environment, and consequently, it could be firstly affirmed that some general principles or fundamental principles are applicable, such as the principle of prevention, so established in the 1972 Stockholm Convention and Declaration in its Principle 21, according to which the responsibility for damage to the environment caused by activity under their control determines the states are responsible for damage to the environment caused by activities under their control. But the main legal reference is a text that was referred to before, that is the ENMOD Convention, that in a certain sense prohibits the military and other hostile use of environmental modification techniques, meaning all those techniques that alter the dynamics, composition, or structure of the Earth and outer space. This convention could potentially reinforce the limitations established in Article 7 with regard to hard-killed weapons, so as anti-satellite weapons, as the production of space debris associated with the use of asset weapons could be qualified as an activity altering the dynamics of space environment and damaging other space objects. However, there's a problem, that is the mental element. So all the environmental modification techniques that are prohibited in the ENMOD Convention must be intentional, and there is a high level of intentionality. And this mental element is absent in the use of hard-killed weapons, since the production of debris is an incidental consequence of the conduct whose primary purpose is the destruction of the space object. However, this limitation is not referred to in Article 35, so in international humanitarian law. As we said, international humanitarian law is applicable when there is an international conflict in relation to the existence of hostilities, but we have also seen that the low threshold of intensity could allow in the future, in case of military activities in outer space, to affirm the existence of hostility potentially in outer space. Article 35 uses a language that is similar to the ENMOD Convention, prohibiting the use of means of warfare that cause widespread, long-term, and severe damage to the environment. If we look at the commentary to the article, we can affirm that the production of space debris is first of all widespread because it covers an area of several hundred square kilometers, is severe because it involves serious disruption to economic assets, and these are the definitions included in the commentary, and at the same time is long-term because it would last more than a decade, and that's obvious. We can also derive, these are just the last reflections, that the production of debris also influences the conduct of hostilities and would influence the conduct of hostilities of states, since the principle of precaution at this point would oblige states to take into account the orbital trajectory in which the debris would potentially circulate, forcing them to prefer viable alternatives such as non-kinetic weapons or explosive weapons when states would be involved in military activities in outer space. Therefore, to conclude, this intervention has attempted to show how the development of new military technologies that can potentially be used in outer space has accelerated in recent decades at a pace that the law has not been able to keep up with. The outer space treaty are rather outdated and are not able to impose substantial limitation on new weapon systems that without affecting the space environment, interfere also with the normal functioning of satellite systems with potentially disruptive consequences for the provision of services on Earth. Multilateral cooperation also leading to results more informal than general conventions that are difficult usually to agree upon in the current context should therefore be strengthened to address this risk, also with a view of reducing tension that could lead to space conflicts in the future. Therefore, based on ongoing research projects such as the Humera Manual and the Paros Treaty, this process of multilateralization could avert the risk associated with widespread militarization of outer space. Thank you for your attention.
Thank you so much. Many interesting points in this session, in my opinion, but I do not want to abuse of your time and attention. So the floor is open for any question. First and second, please.
Thank you. I have some doubts about the references, Dr. Amoroso, in your presentation to the Liability Convention and the Article 7 of the Outer Space Treaty in relation to the fact that there is no doubt that a state violating international law is responsible under Article 6 of the Outer Space Treaty, and Article 6 deals with responsibility, which also leads to responsibility for damage caused by violation of international law. While Article 7 deals with liability and the Liability Convention deals with liability and not with responsibility, which is intended as the duty to compensate damage caused by basically lawful space activities. And it is very much debated the fact that the Liability Convention may apply to military activities intentionally causing damage. What is sure is, I mean, in my view, if there is a breach of a jus ad bellum, it would be responsibility under jus ad bellum, which would apply. If there is a breach of humanitarian law within an armed conflict, it would be humanitarian law, which would apply. I personally have doubts about the possibility to use the Liability Convention to deal with damage caused intentionally by the use of weapons in outer space.
Just maybe to clarify, like of course, as I said before, in the case of which the military activity leads to the application, so to the outbreak of an armed conflict, in that case, international humanitarian law would apply. Obviously, the analysis was related to all those military activities that, in a certain sense, for now, at this stage, are lawful, because are not specifically prohibited, for example, by Article 4, and as lawful would allow for the application of the responsibility liability regime of Article 7. It is debated, but in a certain sense, it could be a way to limit the recourse to hostile. We define them hostile activities. Hostile activities maybe brings us to mind the legal framework of IHL. We are referring to activities that, at least in cases in which there is no material damage, are activities that cannot be qualified, as I said at the beginning, as hostile. But in this case, it could be interesting to observe whether these activities that are, in a certain sense, not for IHL, but in generally hostile because interrupt fundamental services, could give rise to consequences that would qualify as damage in Article 7, because they are for sure intentional. And but I don't know if just the element of intentionality would exclude the application of Article 7. I think.
Yes, if I may, I mean, this would be in any case harmful interference or a violation of other principles or rules of international law. And I think it is doubtful. And anyway, I think also in this case, it is, I don't say, I mean, it has to be excluded 100%, but I mean, I think it is anyway very much debated, the possibility to apply even in such kind of cases of these instruments. But anyway.
Matter? Yes, please.
So this kind of picked my brain a bit because, as my colleague said, the rules of war apply in this case, and they mandate the way to conduct lawful hostilities. So technically, the damage done would be lawful in pursuit of lawful activities under the rules of war. You said the due regard principles of the Outer Space Treaty might apply, and that would make them unlawful. But because we have sort of the ICJ decision in the wall case, sort of humanitarian law is lex specialis when it comes to combat activities, which would make use of this type of weapons of war in space, long as done within humanitarian law, lawful. So I think I'm kind of on your side on this debate. Sorry.
Okay, I will be brief. Thank you everyone for great presentations. If we would have time, I would ask everyone a question, but I will be really short and ask just one to Professor Ayoski. Sorry, non-professor. You have to be really careful with these titles. Yeah, so in your presentation, you mentioned certain aspects that I think are following into the domain of space ethics or philosophy, however you want to call it. For example, what do we do when we interfere with another, if there is another form of life, or do we preserve environment for the environment's sake, and so on. And I'm interested in where is your opinion, what is the relation between these kind of issues and the lawmaking? Is there a place for them in the lawmaking? How do these interact with the lawmaking process? And do you think that should be decided on a preliminary phase? Or is it possible to do it simultaneously? Thank you.
Okay, thanks for the question. The Open University has a project on astrobiology. And whenever I have a chat with them about how likely it is that we're going to find life outside of Earth, they are pretty sure. Mostly because we keep finding water, liquid water in outer space. And whenever they've looked for life in extreme environments on Earth, where there's water, there's life. And there's definitely been billions of years available for life to evolve outside of Earth. So they're relatively sure. They're just are very bugged by the fact that it takes 20 to 30 years to launch any mission, to fund and launch and prepare any mission. So they're just waiting for some confirmation. So that means that I've spent some time thinking about this, both from a philosophical, ethical point of view, and both from the legal point of view. That's why sort of I think personally that the precautionary principles and the preventive principles, the hard law principles in environmental law will apply, that we can use sort of the protection of biological diversity, the CBD Convention, the Convention on Biological Diversity, and especially the latest addition to the law of the sea, the High Seas Treaty, as sort of an example of norms that we can use. So I hope, I envision in the future that we might have space protected areas where we specifically do not have space activities. Also, the International Scientific Union has COSPAR, essentially, part of the International Scientific Union, has issued its planetary protection guidelines, which if you talk to any scientist who do planetary sciences, they would say that that's the gold standard, and any mission that they plan it based on those planetary protection guidelines. So the idea is now how to sort of elevate those planetary protection guidelines from soft law to a bit more harder law. And I think the precautionary preventive principles are the way to go.
So thank you. Any other intervention? Sirio, please. Some conclusion.
I will not conclude in the sense that I somehow concluded yesterday proposing what is important for me is to remain in touch. I think today we have somehow contributed to strengthen the network in space law. Since long there are networks of space lawyers at every level, at the European level, at the international level, which are networks of internationalists. I think that the important contribution of our meeting, of our conference, is the approach we put together scholars of many different legal disciplines and of non-legal disciplines. So as it has been said yesterday by the director of the department, we are going to launch this new center about space law, which will go on through this particular approach, so combining comparative law and international law with all other legal disciplines and non-legal disciplines which could contribute. Case by case, we will see for different space topics which one could be more easily involved. It is much important for us to involve everyone which is interested, so it will not be just a center for space law for the scholars of Roma 3, but it is something that we from Roma 3 propose, and we look for a network of scholars to work with from all the universities, centers of research, from the civil society, from the world of from the environment of the enterprises of the space field, which could be big enterprises or new small and medium enterprises working in this new field. And I would like to another time to thank a lot Professor Zenzenkovic and Professor Resta and the department director who supported this initiative and this approach, which is new for Roma 3. And so it was somehow a challenge, and I think this conference was an important success for such a challenge. And I would also like to say another time that I am much grateful to Dr. De Nicola and to Dottoressa Frattoni, who helped a lot for the organization of this event, the organization before and the practical organization during all the days of conference. I think we all should thank them who have been present in every moment and helped that. So see you soon, and let us stay in touch and work on space law and space issues.